that a test is designed to measure. That's a very short definition. The statement itself normally is also rather short. So, but that construct statement then provides the foundation, the philosophical basis for all the rest of the considerations around the design of the test, the development of content for the test, and the evaluation of the test as a measure of the construct. So that definition is a key one. And then the standard that pertains to the construct statement prior to the development and implementation of an employment or credentialing test, a clear statement of the intended interpretations of test scores for specified use should be made. And for subsequent validation efforts should be designed to determine how well this has been achieved for all relevant subgroups. And so the second part of that has to do with summary of the psychometrics about a test and the measurement quality of that test relative to the construct statement. So if there aren't any questions about that, I'll proceed. But if there are, I'd be happy to address them here.
Just a quick question. Do we have something that we're working off now? I think probably Ron would know.
Yes.
We do.
We start out with examples.
No, I mean the State Bar of California for.
We have something close to a construct, but it's not, because we didn't follow the process of having a construct and then design our exam. What we have close to it is the expected performance or interpretation when we have the written exam grading process, and a similar construct statement we also have from NCD and ABA. So that's part of our discussion, using them as the starting point, and then the proposed construct statement for our current project.
Okay, thank you.
Dr. Henderson, I have a question. I'm sorry, back on the subgroups, the relevant subgroups. What does that mean for us when we're looking at whether or not the concept can be validated for different subgroups?
The standard applies to employment or credentialing tests. And so the subgroups analysis is probably more important for employment testing than it is for credentialing testing, though they are grouped together in the standard. And so subgroups would be people who have completed the anticipated major course of study in comparison to people who've qualified to take the test by some other alternative route to entry. There may be other subgroup analyses depending on the configuration of degrees that might be brought to the table in the candidate population. Some groups do include subgroup analysis based on considerations like ethnicity or race, and that is certainly something that is a subject of considerable interest in a lot of different exams. So does that answer your question?
Yes, thank you.
So what I've done is to pull together a few construct statements from other professional licensing exams. The United States Medical Licensing Exam is the test that physicians take after they have completed medical school, normally before their residencies. And passing this gives them the license as an MD in whatever jurisdiction they have applied to. The test is referred to the USmile. I expect that maybe they don't all smile, only those that pass, but the construct statement for this, the USMLE assesses the physician's ability to apply. I'm going to have to read this from a closer document, thank you. To apply knowledge, concepts, and principles and to demonstrate fundamental patient-centered skills that are important in health and disease and that constitute the basis of safe and effective patient care. There's a lot in that statement. The first is ability to apply. And so what that says to me is that they're not testing the recall or font of knowledge that the individual physician has, but the ability to use that information to make decisions and judgments and diagnose and select appropriate treatment options and so on. And then knowledge, concepts, and principles covers those things that an entry-level physician would be expected to know, be able to use when applying those things. Those are the things that are being applied in the resolution of issues and problems that physicians encounter. Patient-centered skills. Patient centricity has been a buzzword in medicine and in healthcare for the last decade. And so an important point is that these are things that the physician brings to bear in working with patients. And important to health and disease, of course, and then safe and effective patient care. And the words safe and effective are often part of construct statements. We want to do no harm, and we want to do our best to assist. So that's the USMILE statement and some key words from it. Also from healthcare, very, very simple statement for the National Nurse Licensing Exams. Those are tests published by the National Council of State Boards of Nursing, and there are more than 163,000 nurses took the NCLEX RN in 2018. So as simple as the statement is, it's applied to a whole lot of people every year. And so nursing ability is just really where that construct comes down. Not much more to say about it because it's so simple. And the parsimoniousness of the statement probably leads to a broader interpretation rather than a narrower interpretation of what the statement implies. CPA test, and that's published by the American Institute for CPAs, and it is, the statement is, the CPA exam is designed to assess the knowledge and skills entry-level CPAs need to practice public accountancy. Again, a very simple statement focusing on knowledge and skill and entry-level CPAs, and then practice, which is the application. The ARE is the 6-part licensure examination for architecture. The statement is complicated because of the complex nature of that program. There are 6 different parts to the test: practice management, project management, programming and analysis, project planning and design, project development and documentation, and construction and construction evaluation. So an architect communicates with clients to determine the purposes for the building that they are to be building, and the relationships among the people who will be using the building, so that the space functions as a useful building for the organization. And then the project planning is where I must be inadvertently pressing a button over here. I'm sorry about that. And so that's the problem-solving part of the test in a real sense. Project development and documentation, the drawings, the specifications based on the design, and then visiting the construction site and overseeing the various trades and professions that work together in the construction of a building. And so that statement says that the ARE is designed to assess aspects of architectural practice that affect the integrity, soundness, and health impact of a building. The exam also assesses an architect's responsibilities within firms, such as managing projects and coordinating the work of other professionals. And so some key words, aspects of practice, again, that practice word, the application, integrity, soundness, and health impact of a building. So that gets to the product that an architect develops. Responsibilities within firms, practice management. Should sound familiar to folks in this room. And then managing projects and coordinating the work of other professionals. And then the PE exam. The PE exam starts with the fundamentals test, and then after the engineer has practiced for 3 years, he or she is, or 4 years, I think, is eligible to take the test. The construct statement here is really the first sentence. It's designed to test for a minimum level of competency in a particular engineering discipline. And so after they've been on the job for 4 years, they specify which discipline they would like to seek their PE license in. And so those are civil, electrical, mechanical, whatever. And then their PE license is related to that specialization. And so Jackie asked about the current statements, and for the NCBE and the ABA, it's here. It's a long one. The bar examination should test the ability of an applicant to identify legal issues in a statement of facts, such as may be encountered in the practice of law, to engage in a reasoned analysis of the issues and to arrive at a logical solution by the application of fundamental legal principles in a manner which demonstrates a thorough understanding of these principles. The examination should not be designed primarily to test for information, memory, or experience. Its purpose is to protect the public, not to limit the number of lawyers admitted to practice. And so the construct statement there, if it probably wasn't intended to be one, and there's some things that I would argue should not be included in the statement. That is the phrasing, the word should is the biggest issue I have there. The bar exam tests the ability.
It's on again.
Well, it's on, so we'll okay, I'll try to speak up as well, and thanks. Okay. So the issue that I have with this is, a construct statement should be definitive. The bar exam tests the ability to do this rather than should. So this statement sounds rather aspirational, and we want it to be, a statement of what is being measured.
Just where is this statement in use? This is for the uniform bar exam?
This is a statement, I think, currently adopted with some revision. I don't know how many different revisions, but currently in 2019 was adopted by ABA along with NCBE as a statement of the purpose of the bar exam.
Where did you find it?
I found it in a document from NCBE. I can trace the specific, it's adopted as a rule, part of the ABA rule. I can get the source to you.
I'm just taking a wild stab of speculation where it might appear. There's a comprehensive guide to our admissions where it may appear, but I don't. When I was in board, I don't recall ever seeing that. That was a long time ago, so I just don't know where it's at.
That's likely correct. It's definitely not associated with the UBE specifically. I think it's a general statement of bar exams in general, not.
Yeah, I just don't know if the NCB board has adopted that as its purpose. The NCB is well, I don't want to get too far in the weeds.
We love it over here, right? We can go home now. But I think this is an excellent foundation for, right? We're going to be doing our own for our state's bar. I mean, there's a lot to like in that. So, Ron, I'm glad you pulled that up. I think that's a lot to like.
So I'd like to question that. I mean, you described it as aspirational. I also think it's defensive, right? Twice as defensive. It says it's not to test knowledge, and it's not to limit access to the profession. Should a construct be defensive
No.
rather than prescriptive?
I would say that the last two sentences would not be part of a construct statement that I'd like to see.
I think, if I may, it is in the comprehensive guide to bar examination with the ABA, and of course the ABA is a trade association, has to be very careful about antitrust issues. Neither the NCB or the ABA are licensing authorities themselves, and I suspect those last two sentences are probably a nod to, I'm just guessing, antitrust, what might have motivated it. But, and I mean, we can debate what should be in the statement, that'll come later, but I think that's what those last two sentences, which are people saying, what's that in there for? Well, antitrust.
The other thing that this document where this came from says is that there's a necessity, this is all guidance to states, says that there's a necessity of written examination. Wow, that's annoying. That they're basically saying required to be passing some sort of written examination. I don't know if they therefore mean not just multiple choice or if that's included, but there's a lot of guidance there.
Yeah, the language should probably comes from the fact that the NCB and the ABA are not licensing authorities.
And so this sounds like language that would be drawn out of something like a candidate handbook for the California bar exam. And so your answer should demonstrate your ability to analyze the facts in question, to tell the difference between material facts and immaterial facts, and to discern the points of law and fact upon which the case turns. Your answer should show that you know and understand the pertinent principles and theories of law, their qualifications and limitations, and their relationships to each other. Your answer should evidence your ability to apply the law to the given facts and to reason in a logical, lawyer-like manner from the premises you adopt to a sound conclusion. Do not merely show that you remember legal principles, instead try to demonstrate your proficiency in using and applying them. And while obviously this is written to a candidate for the test, I think that it does give pretty descriptive language around what the test is designed to measure as well. And so I have taken the liberty to draft a simple proposed contract statement for you, based on the practice analysis. And so the statement would be, the California Bar Examination assesses proficiency in validated legal topics and competency areas that are required for the entry-level practice of law and effective service to clients. And in this, I'm stressing, the word choices here surround proficiency, which I believe, another commonly used word in constructs is competence or competency. My understanding is, as I've worked in my career in credentialing examinations, that there are a lot of attorneys that shy away from the word competence, but are happy with the word proficiency. So I'm not quite sure the basis for that. I feel like they're both fine words. And then we have validated legal topics and competency areas, and so certainly those those provide a sound basis for the test in terms of content framework, and then required for the entry-level practice of law, and that alludes to the intended candidate population, the target audience for the test. And then you've seen a safe and effective service in the other, a couple of the other construct statements. So I included effective service to clients here. I couldn't think of a word to address safety. Certainly when we think about the practice of medicine or work in healthcare, safety makes a lot of sense. Safety in the practice of law seems certainly, I mean, there's certainly harmful events that can occur if the attorney is not proficient in some area of law or some area of service to clients. I chose to go with the positive statement about effective service to clients rather than to address the safety side, but certainly if you have suggestions around that, this is a proposed draft, and I want to emphasize both of those words. I'm not married to this.
I think a good analogy to the safety piece could be ethics or ethical behavior, something along those lines. It doesn't capture it completely, but that's definitely an important component of the practice.
I agree and would say effective and ethical service to clients.
I have a quick question, Dr. Henderson. So validated legal topics and competency areas, what does that mean? And I have another question. So so this seems to be more narrow than what we currently have. It's kind of taking out the IRAC, like you issue spot, you need to know certain areas of the law to be able to look at the facts and come to an conclusion. So why are we going more narrow?
So the first question, the validated legal topics, what makes them validated is that we surveyed 19 of them in the practice analysis study, and there was evidence to support all of them, some more than others, but they were validated through the survey data that shows endorsement from the people whose practice whose practice makes those statements relevant. And then validated competencies. We have 4 areas of responsibility, and across the 4 areas of responsibility, there were 13 competencies. So that's where that came from. That's a pretty high-level descriptor of what we did. And so there is less specificity here than in some of the others, and I'm certainly not opposed to augmenting this with the desired level of specificity that the group lands on. From my standpoint, more is said with fewer words. So that's how I got to this. You'll note that in general, for such fields as medicine and architecture, the statements are not long. They are longer than the one I proposed here, but they are not long statements. They should be very straightforward statements of what it is that we intend to measure.
So my observation, Dr. Henderson, is this. I like this. I prefer this to the existing statement because it is briefer, and also when you talked about the medical standards and the nursing standards, as you stated, they were patient-centric, right? But when you look at the existing California lawyer statement, clients are like non-existent on that list. It's more like a job description for being a U.S. Supreme Court clerk, which is great, but that's not what most people do. So this is more, I think, more holistic that way. I do agree with the comment that validated is kind of a scientific term that maybe not a lot of people can wrap their heads around. Maybe there's a different adjective we can use that shows that it's these aren't just arbitrary topics. Standardized, I don't know, whatever term isn't as peculiar as validated.
Peculiar to us.
Yeah, yeah, no, it's an everyday word for
Right,
me.
right.
But
And-
maybe something like recognized or established or something like that.
Yeah.
And my last point was, you asked about the word service. I think representation is a word that we use in our industry, but service, is a little more watered down, I think.
I just want to concur with Zahner. I like something that's brief. I think, having been a life sciences lawyer, safety and efficacy, of course, is a core of that. That's the standard of the FDA. I agree with Emily, and I think that we should get ethical in here because I think it is the core of our practice as we understand it. I like representation. This is going to get to the issue we're going to talk about in a little bit. We've validated a lot of topics, but I think what we've shown is that you can't test and you shouldn't test on all of those topics because many of them are relevant only to a very, very small percentage of lawyers. So I would suggest something like core, because there is some core area of, I think, both topics and competency areas that are common to many, if not most, lawyers, and that's what we ought to be focusing our testing on.
I had one more quick comment. I know this is a small percentage of our applicants, but we do have a number of lawyers who are experienced from other states who take our bar. So the part about for the entry-level practice of law, we do have a percentage of applicants every time that are not entry-level lawyers, but are sitting for our bar. So I don't know if that exactly reaches those, but throw that out there.
Because those candidates are part of the mix and would not be a dead-on match to the target audience, if I were doing psychometric analyses for your bar exam, I would exclude them from the studies that would be used to validate the measurement quality of the test for a statement like this. It is very common for organizations to establish a calibration group of candidates, which represents the defined target audience for the test, and restrict the studies that validate the test as a measure of the construct to those groups. But that's a future consideration and some policy for the bar down the road as it goes. So I've been taking notes in the conversation, and what I have so far, and of course it doesn't show as it's modified because I'm not working in the computer that's driving this, but what I have heard you say is, and I'll read the modified version, the California Bar Exam assesses proficiency in core legal topics and competency areas that are required for the entry-level practice of law and effective ethical representation for clients.
Well, I had a suggestion, instead of validated, maybe recognized, or instead of core, just another idea. And then also to follow up on your point previously about the idea that we're not testing every single topic, maybe common legal topics and competency areas.
So we're anticipating some of the decisions that we'll be making a little later in the meeting. The reason that we're doing this one first is that the standard that I cited does say that this is the first step. And so we want to know what it is we want to measure. What I'm hearing is recognized in the place of core. That's certainly a possibility, but we need to make some kind of decision about what it should be. But we will be looking at, later in the meeting, some analyses that Ron and I have done jointly that end up with ranking the legal topics and the competency areas so that you can decide if there's a threshold that you would like to apply that would help to distinguish those legal topics and competencies that should be tested on the bar exam and those that we can afford to not assess on the bar exam.
Thank you. I don't know if, Stephen, if that's a motion with respect to the word insertion word core. If it is, I would second it.
Yeah, I'd like to ask Neil, because I'm a little bit, I mean, recognized to me as a non-scientific word, alternative to validated. I mean, we would recognize legal topics, a vast, vast range of legal topics, which I don't think we intend to test on. So I think there really is a critical difference between either recognized and validated or core. So I would just ask if, because you seem to waver a little bit on that. I'm just wondering what your thinking is.
I was just thinking that maybe validated sounds too esoteric, and that recognized conveys that point. But on the other hand, if you're trying to convey that these are essential topics, then core, I guess, works just as fine.
If I could, I didn't finish with my thought, if I could. Now, I second, if that's a motion, I second. I think it's reasonable. And I don't know if we want to have it here, but you know, we've been talking about validity and we haven't talked a lot about reliability. But obviously, I think the test, whatever it is, what topic it have to be reliably tested to, and maybe that appears elsewhere. But and I assume we're not restricted from coming back to this. It seems to me it's a pretty good starting place. So,
yes, Leanne.
Usually, okay, so when it says we're assessing proficiency in like what? Is it application of law to the facts? Because it says it assesses proficiency in validated legal topics. Well, what does that mean? Does that mean memorizing legal topics? Does that mean knowledge of the area of law and then applying to the facts that are presented? Usually someone is proficient in a task or a skill. So that's why I was saying that we should keep the, if we could just go back, I don't understand why we didn't have a printout of what you're showing here, but it would be good to refer to as we're having this discussion. So that's why I was saying earlier that we should keep that IRAC language somewhere in there. We should throw a sentence or somewhere in there, because right now it's just kind of vague and ambiguous.
Donna, did you or somebody down there have a question?
Yeah,
Comment?
so I understand that this is a construct statement, but it can also be looked at as sort of a mission statement for the bar exam. And it jumps out at me that for the state bar to have something like a mission statement that doesn't include the words public protection, it just sort of raises a question in my mind, and I can see weaving it in at the end where we talk about practice of law, ethical and effective service to clients, and protection of the public.
Well, I'm not responding to that, but I think it's a good point. I was thinking about the need to retain the concept of validation, although perhaps not necessarily in the construct statement, but somewhere, and it may be a state bar rule or even a rule of court, because I do think in perpetuity going forward, we want to ensure that decisions that are made about what is tested on the bar exam are derived through a validated process, not an intuitive one, not a qualitative, subjective one, but there is a requirement going forward that when you select topics for the exam, that is done pursuant to a validated analytical process. So, but perhaps it doesn't need to go in the construct statement, but I do think we need to retain that concept somewhere, right? So that 30 years later, we don't just find ourselves with the bar exam with topics that were selected because people thought it was a good idea. But that could just be a note for the bar really to work with the court. And where do we hold that concept if not in the construct statement?
Donna, could I ask you a question?
Okay, sure.
Oh, sorry.
Yeah, so I was looking at Business and Professions Code 6001.1, which is where it says that the top priority of the state bar should be public protection, partly as that statement was first put up there. And I was thinking kind of the same thing, but then Amy and I were kind of having a sidebar here about what the duties of the bar is as a regulatory body, which is public protection, as opposed to what the attorney needs to do. And I think the concept of ethical kind of gets more at what the attorney needs to do than the concept of public protection, which is what the bar needs to do. So I think that there needs to be some alignment between what it is that individuals do as attorneys in their practice that does protect their clients and that fulfills their duties as attorneys, as opposed to what the bar does. Somehow that needs to be woven in, and this concept of public protection does need to come in, but perhaps not as public protection per se, because that's what the bar does, not what attorneys do.
And my question is, there's been a recent modification to the mission statement of the State Bar that talks about access and inclusion. So I would say if we're going to talk about what we're trying to achieve, I don't know why one would give precedence to public protection over access and inclusion. So it gets to your point. This is really about what we're expecting from attorneys, not what we're expecting from the State Bar.
Yeah, and access and inclusion are defined in that statutory section that Doug referenced as part of public protection, part of the way we carry that out.
I have just a more 30,000-foot level question, I guess. So is this designed, so this is designed to indicate to the world essentially what the California bar exam is measuring. Is that right? So it still doesn't say how we're measuring it or what the competencies are, or what the topics are, or anything like that. So if we think this is the mission statement, so then this body will also develop the vision of how that all works to carry out your metaphor. Is that right?
So there is a follow-on document that details specifications for the test, where the design of the test is articulated, the scoring models are described, and the psychometric analyses that document the measurement quality of the test would be defined. So there is that follow-on document that I would expect to be developed.
And does that also, to Leah's point about sort of where the validation goes, and maybe also to your point as far as like how we get at the IRAC and other things? I don't know, but maybe it doesn't. But.
No, it does. Emily. Okay, so you
and
said,
is that beyond the mission of this group?
Well, it's beyond, I think, perhaps the statement. We certainly have the construct statement, and then I think that once we've discussed and it's a chicken and egg conundrum, the item formats that are best for assessing this construct, and then what things are not testable. So those two things going together play into the next phase.
Well, that's my, that phase is not necessarily, is that phase within the charge of the working group is my question. Yes or no? I mean, because this is our last meeting, right? So are we?
I would say
Oh, we have one more, okay.
no.
I'm hoping that after this, we are going to go to looking at topics and competencies, right?
Yes.
Okay. And then I think what that next phase is that's not under the charge of this working group is the actual test design, right? Is what you're talking about. So we'd have the topics and the competencies, and then it is how do you best test those? And it goes to Sinead's comment as well. So I think, but we'll be making great progress if we can get our topics and competencies identified. Yeah.
And honestly, we can come back to this statement after we've reviewed those and made some recommendations for the policymaking body to act on. But definitely, so the draft that I have of this at present is the California Bar Examination assesses proficiency in core legal topics and competency areas that are required for the entry-level practice of law and effective ethical representation for clients. The term proficiency was up for discussion last, and I'm not sure that we landed on a term.
I think it's of clients, not for clients. Representation of
Representation
clients.
of clients? Thank you. So what do we think about the word proficiency or competency or alternatively, ability to apply or practice or something along those lines?
Oh, wait. It's a little hard without seeing in writing to figure out where we are in the draft, but I would only add also that we do more than represent clients, we also advise clients, and I think that's an important distinction. You might want that.
Looking at the dictionary definition of proficiency. May I? So the one that pops up, and again, this is just an observation, not a recommendation. So it says a high degree of competence or skill expertise, so a high degree. So I don't know if other people think that in terms of common usage, proficiency suggests a higher standard or a similar standard or something different. So in terms of giving similar, they give skill, skillfulness, expertise, experience, ability, capability, and capacity. Sorry?
It says assess proficiency, so it's not.
But how you read it, Mr. Farrell, Stephen, is different, though. If we're assessing proficiency, if we're assessing skills needed by entry-level attorneys, proficiency, it seems kind of opposite to that.
I don't know how I read it. I was trying to get Jim's comments because the term of art, right, is competence, right? And so I'm just wondering in terms of what we're thinking or what we're messaging by using proficiency in terms competence, and I don't know. I'm just really posing the question to this group because I agree with the comment that was made earlier by a commentator. I think when a bunch of people talk about things, you tend to get pretty close to the truth.
So the word proficiency is an alternative to the word competence. Is this on? Yeah, it is. And so I think the difficulty that the word competence provides to attorneys who practice in credentialing, who specialize in credentialing, is possibly the misunderstanding that that once a person is licensed, that they remain competent. And actually, the real concept is that on the day that they tested, they demonstrated satisfactory level of, and you name what you want to call it, competence or proficiency or ability, but that there's no guarantee the very next day that they have maintained that level. And so I think the word competence is interpreted as longer lasting, though so is proficiency, in my opinion. I don't really see much, as a psychometrician, much.
The system has detected that a minimum number of lines are connected to this conference. Do you want to continue your meeting? Press 1 to confirm.
Don't answer that.
If there is no response, the conference will end.
Oh, yeah. I'm thinking, why don't we just use words we recognize in terms that we recognize? So we say minimum competence all the time. Most lawyers have some sense of what that means, and literally it means entry-level ability. So why don't we say minimum competence instead of proficiency, if that word is an issue?
Jackie?
So as I read this, what we're testing is proficiency required of an entry-level attorney. So it seems like we take care of narrowing it to that in how we've written it. So what I might determine to be proficient for a first-year law student exam is going to be very different than what I would consider to be proficient for a third-year law student's exam. So this exam is testing proficiency expected of an entry level. I think it goes back to the unanswered question, which is, well, what is that? But as I understand what you're saying is we would have an attachment to our, or a supplemental document that would describe proficiency for an entry-level attorney, in which we identify what it is we're going to be testing and looking for in those answers. Because that proficiency piece is the core to the pass piece, the pass rate, the pass score, everything. So to be able to define that clearly, if not here, which would make sense, to wait to supplement it later seems absolutely key to everything that we're doing right now.
Well, that's actually a good point, because the point was made earlier, and accurately, that the word proficiency and an entry-level attorney are usually, not consistent. But proficiency required for an entry-level attorney, that's a whole different set of standards, and so I get the point, and I think that qualifies it adequately to take it out of what we would normally characterize as proficient.
Right.
Is there any way for us to get up the draft that we're looking at on here? Because it's just really hard. I've got it here,
Can I
but
just do it on that computer that's? No?
Just I'm a little concerned we're going to get bogged down on this, where we've got a lot more work to do, and I think we have to take it to heart, the suggestion that we may have to come back and look at this. And in support of that proposition, that if you looked at what the current state bar construct statement, if you'll call it that, and NCB and ABA, although that wasn't a construct statement, they're largely a function, I think, of, it's a more narrow function. It's largely a result of what has been discovered through experience and experimentation as what's feasible to do in a 2-day examination or whatever limited examination. So, we'll get into the issues of what should be, well, maybe we won't, as how the test should be designed, but I suspect there could be significant revision in light of what we find out as we go through the process. So, the question is, what can you actually do on a bar examination?
I was just suggesting to Dr. Henderson that we set this aside over lunch. He can draft a revised version for you all to review, just because it's going to take a little bit of time right now. Move on, kind of in line with your comments, Greg.
Thank you.
I would just like to add, in the way that I look at the difference between proficiency and competency, not as a native speaker, but more in reference to what I often hear in describing the ability in language performance. There's this very important distinction between language proficiency and competency. And competency usually assumes that you have the basic proficiency, and then competency has to do actually performing the language based on the proficiency that you have. So there's that distinction between the underlying knowledge versus the ability to apply that knowledge as represented by the concept of competency. I'm not sure whether psychometrically or in terms of just the English meaning there's any relevance, but that's how I see the difference.
I just think we run into problems with that concept when we also have competency areas. So we're using proficiency in core legal topics and competency areas. So you're saying be proficient in competencies. And so if we're going to define competencies at some point, but we can't, I don't know if we can say areas of skill or something other than competency areas. That's a term of art we use and flow around, but I don't know that, anyway, just pointing that out for lunchtime.
So so we'll come back to this as a draft proposed statement, and and we can incorporate revisions as we deem appropriate. I guess wrapping this up, I would say that as the design of the test as decisions are made around the design of the test and the specifications that would be developed, the definition of whatever term we land on for proficiency will be operationalized both in terms of the item formats and the way that they're targeted to the target audience, to the scoring of the test, to the passing standard that's applied, to the messaging that the State Bar and Supreme Court use around the bar exam and the appropriate interpretation of scores. So this is, and candidate handbooks as well, or information available to them will go into more detail. So we can attempt to define the word proficiency or competence ourselves. We will never stop in that process, I can tell you, based on experience, but that doesn't matter. So then we'll come back to this in a little bit.
So our preparation for the meeting today is really just to follow the sequence of presenting a construct statement as conceptual framework or abstract description of the characteristics of what we expect the ability, competency of a bar exam takers. In terms of the data, that's what we used to put all of those concepts in a more concrete manner. And from the last conference call, we had an understanding that the data that we have covers so many different topics and different layers of complexity. The best for us to come to a decision about the very specific question of what topics or competency areas based on the design of the survey should be or should not be covered on the bar exam. So we went through a series of just transformation of the data. What I present will be just going over the process of constructing these averages or composite indicators based on all of the ratings that we have. One of the challenges earlier that we ran into in comparing the results from the ESM and the traditional survey is one of the important indicator, frequency. ESM is measured by percentage, and the traditional survey is measured by 5-point rating scale. And also, in order to facilitate creating these composite indices, it's best to have everything transformed into some standardized scale. So what we use is aggregate all of the data, whether it's percentage distribution or 5-point scale. We created a standardized scale based on standard deviation, which is any distribution of values in a sample. You can specifically say, this is the mean that we want, and this is where we want the standard deviation to represent. And to create a scale that's easy to interpret, we just set it at 10 as the median, and 1 standard deviation at 5. What that means is whether it's a 1 to 5 rating average or percentage distribution from 0 to 100, you can look at it based on this common scale with a mean of 10. And then when you have a value, for example, on that distribution of 16, that means it's a little over 1 standard deviation away from the mean. So that's the background of how we use this standard measure to have all of these data together. And this shows the results of converting the percentage from ESM. On the left-hand side is percentage distribution of all of the legal topics. You've seen before in this descending order, civil procedure is ranked the highest all the way down to secure transaction. Civil procedure in terms of percentage is close to about 13%, and secure transaction is less than 1%. On the right-hand side is the transformed standardized scale, which gives you the same information in terms of the ranking of all of these different topics, but except it's based on mean of 10 and 1 standard deviation of 5. And you can look at any of these based on that same standardized scale. And this is the same way of showing whether you use the original frequency distribution in terms of percentage or standardized scale of 10 as the median, there's direct linear correlation between the two scales. It's a straight line. And this is intended to show when you have all of them, the ratings converted it into standardized scales, it's easier to combine them, whether you multiply them, adding them, or taking the average, so that in all of these composite scales, you'll be able to capture the different ratings in a single number. So what I demonstrated here is first to look at frequency distribution based on that standardized scale, and the whole entire chart is arranged based on descending order from the highest frequency in standardized scale. And the two additional composite scales, F and H, is combining frequency and criticality or harm, which taking the average of the standardized scale of the two. And the third one is, in addition to frequency and harm, I also added from ESM that's available only depth of knowledge scale. So the interpretation is the first one, drafting and writing, that obviously because of the descending order has the highest frequency. But then if you incorporate the measure on harm and depth of knowledge, it moves a little bit to the left, to lower the composite score a little bit than just measuring frequency alone. Here is an example that goes in the other direction. Frequency itself is low, but if you add the harm and depth of knowledge, specifically to this negotiation and closing, the rating for those two elements gives you a little higher composite score on that. So in a single view, you'll be able to see the result of using all three ratings. And the third example is on all three measures, whether a single frequency or the two composite, they all come together very closely, specifically related to maintaining client relationship. In other words, another way of seeing this is whether you look at frequency, criticality, or depth of knowledge, some are very close in all of these measures in terms of the overall ranking. Others depend on the specific measures. It tends to increase or decrease. And when we try to have this composite score, looking at the ranking of whether it's competency or legal topics, we want to make sure that we cover not only the first year, but also the first 3 years. First 3 years is because the traditional survey has the first year and the second and third year, and we also want to make the results comparable. And when we compare all of these composite scores in terms of the ranking of the competency areas, looking at whether first year or first 3 year results, it's very similar. That helps us to answer the question of how do you define entry level, to the extent that you see differences between first year and first 3 years that give you some sense where you draw the line. And similar results based on all of the same standardized scales to look at instead of competency. This is the legal topics.
Can I ask a question?
Yes.
I'm not sure I understand the 10. Does that mean, in just lay terms, less than half? Like if you're on the left side of the 10, between 0 and 10, that's not very...
It's not an indication of importance or threshold that we necessarily want to establish there. But statistically, it's very clear that to the left, it's lower than the mean, and to the right, it's higher than the mean. And this, as an example, of civil procedure, its frequency is 23. What that means is it's almost 3 standard deviation away from the mean. In terms of frequency, it's a very large percentage of the overall frequency representation in terms of how often people use different knowledges. So it gives you a sense of how far away they deviate from the mean. So to the left, that vertical red line is just the visual aid to see how they deviate from the average.
So, like, again, just trying to be very simplistic. Absent an overriding policy reason, you might have an approach where you said, if all three, so if the frequency, I forgot what the frequency and harm and the frequency, harm, and depth of knowledge, if all three of those were to the left of the 10, you might say we probably shouldn't be testing those. Absent an overriding policy consideration, like I can immediately think of one with constitutional law, where you think we just want people to know that. But is that
Yes.
how you might use this?
Yes, yes,
Okay,
exactly.
all right.
Yeah.
I think Leah's really hit on an important point, just to emphasize it. When Dr. Henderson was going through the question of how we decide these issues, and we decided, I think, that we're going to exercise judgment, or the group will exercise judgment, which may override, in certain circumstances, what that hard data would show. So I think it's a really important point, and constitutional law is a perfect example.
Yeah, so the sequence of using data to make decision is after looking at what the pattern of the data shows, then any other factors should be part of the consideration would be the second step. And you can clearly see some examples where the data alone might make it difficult for you to make the decision. A clear example is constitutional law and professional responsibility. They're not ranked very high.
One
So,
point
Ron-
that I,
oh, sorry.
just one point around the interpretation that might give you some comfort about things that are below that 10. About 68% of the indicators, whatever you call these bubbles that Ron has created, about 68% of those are going to be within plus or minus 5 of the 10. So the 10 is the average, and about 68% will be in the range between 5 and 15. So being below average is not necessarily an indicator of, lack of validity.
So, another side of the coin on this issue. So, I mean, this conversation about particularly PR and constitutional law, I think that one could argue there are very, very clear policy reasons as to why I think many of us would argue that those should be on a bar exam. The one that I'm scratching my head over is employment law. Not in the sense that I disagree with these findings, but I really do question the practicality of testing employment law. It'd be interesting when we get down to the subtopics in employment law in terms of what that means, right? Because you have, in California, we have very, very, very specific complexities in employment law, which means a very, very California-specific test, and maybe that should be something different the way it's done in places like New York. You also, of course, have all the federal and the federal law. So my question, that leads to the question, would that be part of the conversation? So you think about a policy question from the point of view, okay, despite what this says, constitutional law and PR probably should be in. But despite what this says from a testing point of view, should employment law be out? And that's the question that I'm posing. I hope it's clear.
Yeah, and then another concern I have is that I know in the ESM there was a substantially large other category. And my understanding, if memory serves, is that a big chunk of that was intellectual property. So just flagging that as another data point that may be worth looking at more carefully, or topic.
Yeah, intellectual property as a portion of the other is captured partly in civil procedure. That's how we mapped intellectual property. So when we recode all of those, it wouldn't be a category by itself, a significant category by itself. It'll be just most likely merge with the other existing categories.
I'd like to add that as an old guy, seeing all these new cases coming in California, employment, IP, huge in California. I mean, huge. The levels of litigation, number of cases, 40 plus years ago, 50 years ago when I was in law school, they weren't issues. But if you put your ears to the tracks, that's exactly where the litigation is heading, and it's exactly, in the co-op that I work with, most cases are employment cases.
Is employment a core course in law school now?
Not core, it's elective, right?
If I may on that.
Sure.
No, the core course in law school are the canon that usually is offered in the first year or maybe the first year and a half. It's pretty much, for shorthand, what's on the multi-state bar examination. Employment law is not. Employment law courses depend a lot on, well, contract, but then statutory application. And so, whether it needs to be a separate one, I think the question is, can it be captured in the other ones? But you might make a policy decision, you would include it. But it's not on I don't think it's a core curriculum.
Traditionally, it was a part of agency and employment back in the old days, but it developed because of all of the statutory, implementations.
Yeah, I'm trying to think. There is a study out on the curriculum of law schools, but I do not believe that employment law is in the category of required courses, for example. Not that it shouldn't be. I mean, if the examination said we should have this, that would have an effect on what law schools do. The policy decision for the group is which way do you go.
Yeah, I would caution us against using current law school curriculum as a measure of whether or not something is significant because it's the bar exam, wagging the law school curriculum dog. So the fact that it's not a core course is more indicative of what the bar exam tests than it is indicative of what people do in practice.
Right, I was just answering, but.
And I mean, also to Hosanna's point, again, speaking as a business lawyer, so what goes on in court, I don't know, but I will tell you as someone who practiced business in California, I spent a tremendous amount of my time having to deal with and identify issues that are employment law or intellectual property. I may defer to the experts, but anybody who practices business law in the state deals with those issues on a regular basis. So I think that to me raises a conundrum on those subjects in terms of the bar exam.
So to the extent we use data to make decisions about the bar exam content, and this is clearly what it shows, and this is how we designed the survey categories for legal topics. And after just going through these more as an examples, how we constructed the composite standardized scale later on, Jim will go through similar results for a traditional survey. And we also took another step beyond just looking at the ESM and traditional survey results separately, but created yet another higher level composite, taking the average between the ESM and the traditional to see whether we have cross-validation between the two using all of these standard scales. And that will be the final kind of a measurement of what comes out of the survey results. And when we looked at it, it seemed very reasonable. And even after all of these transformations, I think it's an indication of the robustness of the survey as well as the reliability of the standardized scale. So just finishing this particular chart, and in terms of interpreting the results, we already talked about the results in terms of the potential difference between looking at first year only or first 3 years. Here, as an example, I compare the results between the two groups. The first 3 years, what it shows is higher scores for two topics, tort and evidence. The ratings on all of these were higher than if you're looking at the first year. And two traditional important topics remain at the lower end of the range, and this is something that we also noticed. From here is the traditional results. It's 11:30. Should we continue to go through a fairly long series of tables showing the results from traditional and combined traditional and ESM survey?
Ron, just for clarification, I think this is the case, but the charts you have been going through so far all relate to the ESM, and now
Yes.
we're going into the traditional. So has there been a correlation between the two?
Yes,
Okay.
from here, we'll go through the traditional survey results, and later on you see the findings of whatever the method that we use is very similar, and also a chart showing the correlation between the two.
So what's on the screen at present concerns the 13 competencies. I just thought that it would be easier to get our arms around the method because there were fewer of them than the legal topics. But what you see here is a table that works to combine the findings from the ESM survey and from the traditional survey. And so the first column is the number of responses from the ESM survey, and the second column is the number of responses from the traditional survey. The third column is the average harm from the ESM survey, and the next is the average harm from the traditional survey. Both of those were already on very similar scales, so comparability is fairly evident, and you can see that in general ratings for the traditional survey were a little higher for the potential harm than for the ESM there. The only survey that we had depth of knowledge information on was from the ESM, and I reported it here. And then the frequency from the ESM survey was collected as a percentage. If they indicated that they were performing that competency at the time that the ping was received, then that was counted, and those counts then are turned into percentages here in the next to the last column. For the traditional survey, we used a frequency rating scale. And so the information in the last two columns is not on an unstandardized basis comparable. However, using the standard deviation of 5 and a mean of 10, as Ron described, we standardized the responses, and that is what is shown on the screen now. And so the number of participants is the same because it's the same data. We've just changed from Fahrenheit to Celsius scale, so to speak. And so the average harm then, the distance between the numbers is more dramatic because we had data on a 5-point scale that we've now spread to a much wider scale. And then but still we're looking at information that is separate for the two survey methods. In the next slide, where we have averaged them together, this is the composite. There are several ways to compute composites. We landed on averaging them because it treats each survey methodology equally and is helpful in maintaining the relative scale that we had established. And so
Can I ask a question? Maybe you're going to get to this. If you go back to the prior slide, I understand you're saying the sort of gaps between the numbers look large because they've been transposed to a different scale. But somewhere are we going to see where there are statistically meaningful differences between the ESM and the traditional ratings? Because some of these look very significant, like on the harm side, but I'm just looking at the raw numbers. So in terms of just taking an average, it seems like we would want to know a little bit more about the variance between the two. did you do that? Are we gonna get to that somewhere else?
We have not computed any tests of significance for differences there. The surveys were asked different tasks of the respondents. In the ESM survey, they had a particular case or matter that they were working on at the time they received the ping, where for the traditional survey, they were thinking more abstractly. And so I would say that both have value. We can certainly take a look at, because they are standardized, we can take a look at what the significance and the differences is. Whether there would be programmatic meaning when we observe statistical significance is a different question.
Well, one easy interpretation of the difference between the two in standardized scale is looking at the first establishing client relationship. ESM average harm on that standard is 1.6 and the traditional is 6.5. What it means is the difference is a 1 standard deviation. That's fairly large.
The traditional folks said it was more important or more likely to cause harm if it.
Right, in their assessment,
In
based
their
on whatever
assessment.
framework. And if you look at the other, like issue spotting and fact gathering, based on the same scale, you get similar results, 14 versus 16. And the difference is much smaller.
For harm, but not for, oh, I see.
Yeah.
Not for frequency on issue spotting.
Right, not on frequency.
So is there a policy decision for this group to make with respect to how these two survey results should be treated? Because we're sort of making a decision by just averaging them. Should there be some conversation about that? I know, Neil, I think on our prior call, you raised the issue of sort of essentially weighting of these two different types of survey results. It just seems like we should discuss that a little bit.
So where we landed at the end of the second conference call a week ago was that we needed to propose a model to the working group. And so that's what we've done. Certainly the decisions that we made in formulating the model are debatable and are up to the group. But what we've tried to do is to provide a starting point for the discussion. And so what we've, okay.
Yeah, and so just to follow up on what Leah just sort of described, my concern that I expressed in the last call was the traditional survey just seems to be sort of asking the attorney off the top of the person's head about what is important and what areas they're focusing on, whereas the ESM seems, again, it's just me thinking and my thoughts, that the ESM is actually capturing what attorneys are doing or thinking in any given moment. So that's why I raised the question about whether or not the ESM should be weighted maybe differently than the traditional survey. But again, that's a topic for discussion.
And is now time to discuss that or not? Well, okay, I think Sanjay hit on something here, and I was not familiar with the ESM method of sampling before, and I'm not sure I still quite understand it, where what it grew out of. I had some sense that it might have been originally designed to check to see whether a contractor is actually doing the work that they're supposed to be doing at the time, which would necessarily suggest the importance of the issue to the licensing examination, which runs a little counter to what you just said, Sanjay. But I think it's Neil. Sorry.
I'm not the guy from CNN.
Yeah, right. Sorry, Neil. I think that issue, understanding a little bit more about the ESM and how it's been used before, and it would help me at least to formulate an opinion on the weighting issue.
To give you a simple comparison between the two, first of all, ESM has not been used before in any job analysis that I know of. But conceptually, the difference is very clear. It's mainly having to do with the frame of reference. When you ask an ESM respondent in terms of a rating or criticality or depth of knowledge, what they were looking at is the task that they are performing at the time. So it's more direct measurement of what they think the importance or all of the other dimensions are related to what they are doing. But the traditional survey, it relies on recall of general area of specific task, not at the moment. And it refers to the past 12 months in terms of the frequency and harm. All of these is sort of an evaluative result of them recalling all of their activities in the past. And recall generally, evaluative has some value judgment, but it also tends to have some cognitive bias of recalling only some of those salient elements in any area. But value judgment is an important element of evaluation.
Again, I'm sorry, Neil, I get the point now.
Yeah.
And this is where you see clear difference in two areas. One, professional responsibility and constitutional law. People have very different ratings, more than on the others.
I have just a follow-up so I'm understanding. So if, for example, the establishing a client relationship, that was the example you gave of the difference between a 1.6 and a 6.4, which would be a whole standard deviation different than on the two survey types. So if I am getting a ping and I am in the process of establishing a client relationship, I would indicate that and at the same time assess what the level of harm might be if I don't do it right?
Right.
Is that right?
Right.
So I'm in the moment of establishing,
moment,
okay.
right.
Versus somebody who has gotten a question that says abstractly, or not that
Right.
you're in the moment, but if you didn't do this well and you didn't establish this
Right.
well, this would be the level of harm.
Uh-huh.
Is that right?
Yes.
Okay.
Over
And
a
then you-
12-month period based on their own practice.
Right. Okay.
Again, use that example. The result from ESM is the average of everyone doing their own task related to that area. They might be related to very minor tasks. And the average is simply the sum of all of those relationship-related tasks. But traditional survey, you might be thinking some elements of that particular task or activities. Oftentimes, you might run into some areas that's very important, more than just a simple average of the day-to-day kind of a task. Overall correlation, yes. The more interesting one is where they are different.
And just a quick question. I noticed on the ESM about 10% of the respondents were within that first 3 years. Is that a significant enough response rate for that area of practice or time period in practice for the ESM to provide us with the kind of data we need?
Well, so I'm one of two non-attorneys in the room, so I speak with hesitation here. But if you weren't attorneys, I would speak with confidence in saying that the legal requirement is that we demonstrate that the analysis is appropriate to entry-level attorneys. And so in this study, that's been defined in either of two ways, or can be defined in either of two ways, the data from first-year attorneys and the data from attorneys in the first 3 years of their practice. And so one thing that we'll do in the report is determine any statistically significant differences that exist between the entry-level responses in comparison to those from more senior attorneys. But what trumps it is the data on entry level. So I mean the number in the ESM survey indicating which so I guess in my belief we've got significant numbers in both. On any individual competency, there will be relatively small and numbers or that is in some competency areas, the numbers are relatively small. Practice management, only 58 of the instances of first-year attorneys said that they were engaged in practice management at the time they received a ping. But even that number is greater than the 36 that is normally the minimally acceptable level for the assumption of a normal distribution. So I would say we're on firm ground under both methodologies. The ESM does get at, the instant that the attorney was working on, where the traditional survey is over a broader range and more abstract, but still based on a year in the life of the attorney and the practice that he or she has. One thing I'd like to point out on the slide that's on the screen now, there are 3 composites. The first composite is for harm and frequency with the ESM. So that's an average of the findings for harm and frequency. The next composite is for the traditional average of harm and frequency based on both of those on standardized values. And because they're standardized, they're on the same scale, it's legal to do arithmetic there. And then in the rightmost column is the high-level composite, which is the average of the ESM data and the traditional data for harm and frequency. We didn't collect depth of knowledge data in the traditional survey, so that is not included in that rightmost column's average. But that average does combine the data. Whether you want to give greater weight to this ESM over the traditional or vice versa at the end of the day, right now they're treated equally in the computation of that composite.
So that last, on the screen, the last one just says frequency, but that includes harm?
No, I think the next slide shows the composite.
So the rightmost column, is that
no,
what you're talking
that's
about?
I just don't think the right slide is up, that's what I'm saying.
Need to move to the next one. Yeah, next slide.
I'm sorry. Thank you.
Yes. There you go.
Okay. So I guess I was looking, if you could see what I could see, you would have understood and followed just fine. I'm sorry about that. And so I'm seeing what I'm showing and not connected to that. So it's bad business here. I'll try to keep this in my hand. So what we have there in the rightmost column, so the 3, the establishing the client relationship, the composite for ESM, harm and frequency is 4.1. The composite or average based on standardized values for the traditional harm and frequency ratings is 5.5, and the average is 4.8. And so that rightmost column is averages of the ESM and traditional, so that we're combining both methods together, which does give us the advantages of that each brings to the table and evens out the disadvantages that they may each have. And then this last slide ranks them from highest to lowest for the first-year attorney. And so we could state we could say that those with high values here have more relevance to practice and may be more valent topics to include on the bar exam. So, one decision at the end of the day would be where we want to draw that threshold using which combination strategy. And so what this is based on is first-year attorneys, and then we have the same, and I'm going to skip the detail and just cut to the comparison and ranking for the attorney, based on responses from attorneys in the first 3 years of practice, and the ranking for competencies that we derive from that. And again, the National Conference of Bar Examiners Practice Analysis Study is focusing on attorneys in the first 3 years. So we get a larger number of participants in the mix with this arithmetic, and we have comparability to the national study that's being done at this time. So that may have some advantages, but it's really up to you. I think it's appropriate to go either way on the competency framework as with just first year or attorneys in the first 3 years. On the legal topics side, we have similar information for you. The amount of information that we tried to fit on the screen means that we have smaller font, and I know that that may complicate things for some of us. But again, we have the 3 composites, the one for harm and frequency for the ESM method, harm and frequency combined for the traditional method, and then in the rightmost column, the composite for harm and frequency for both that combines ESM and the traditional. And these are ranked by that statistic from high to low. This is this table for based on first year respondents, and this table based on attorneys in the first 3 years of their practice. It was based on this list that I think I would start the conversation about threshold and how many attorneys to include, whether it's just 1 year or 3 years, based on legal topics first, because that's an area that perhaps is more familiar to members of the working group, and it is more attached to the current bar exam, and then we can.
Can I ask a question?
Yeah.
I'm surprised to see professional responsibility so highly rated when we saw on Ron's chart that it was not. So this is the impact of the traditional survey that coming in. Okay, and
Right.
evidence. I think several of these. Con law goes up.
You can see the difference between the two, like with professional responsibility, ESM is 9.1, traditional is 18.2. That's 2 standard deviation difference in the rating.
And I can see people doing the traditional survey, maybe overvaluating maybe some of these topic areas that we're seeing differences in terms of real day-to-day practicalities, but just my observation.
Social desirability often comes out in surveys.
People think about the 1 versus the 3 years. I think we've really struggled here because, in all candor, we have not grappled with that very difficult question of when we say entry-level attorney, what are we talking about? So now we have some data to allow us to do it.
Well, it's kind of a mixed bag, right? Because for those of us who've been in the industry, right, when you start out, you know absolutely nothing, and you admit you know nothing. And when you're a 2-year attorney, you know everything, and then it takes the next 30 years to forget all that. So there's that. But by the same token, people are not introduced to a lot of areas immediately, because you're one person, you can only work on one thing at a time. So people get introduced to new areas as they practice, still as a beginning associate or even a sole practitioner, right? It depends on what client walks through the door. So I'm not uncomfortable with the 1 to 3, with the caveat that second-year lawyers know more than anybody in the world, because I was one once.
I just say ditto. I mean, I think that entry level is the first 3 years of practice, and even the way the survey is done, it seems to me just focusing on 1 year would be a mistake. We get a much better picture with 3 years.
Yeah, and I think what I was struck by something that Ron showed us in a previous meeting was kind of the consistency in years 1 through 3 and their understanding of criticality that jumped dramatically in year 4, which to me, not just being consistent with the NCBE and the kind of MBE testing framework, but also consistent with what we're seeing in the data that those first 3 years look very much the same in terms of knowledge and skills that they need to, that they participate in.
In terms of rating, yes.
Yes.
Not in terms of percentage distribution.
Correct. But then it's the criticality thing that really jumps out for me.
I would say to use the 1, 2, and 3 year attorney rather than just 1 year primarily. I mean, everybody has said a little bit of this, but I also think that the differences are not so much, and we've got so much to do that to spend a whole lot of time on the difference might be troubling. So I would just use this. I think there are some, but I think policy opinions of the group could maybe make up for some of that. But this is what I would use.
If you look at later on, we have a chart just comparing the difference between first 3 years. Like this is the competency. On the horizontal is the first 3 years. Vertical is the composite traditional ESM combined ratings of first year. And if you look at what's circled there, just that as an example where they fall, there's not a lot of difference between using first 3 years. And then similarly for legal topics.
Does anyone object as a going forward basis, without perhaps making a final decision, but for purposes of the discussion, using 1 to 3 years? We're all good with that? Okay, why don't we?
I have a suggestion for legal topics, just to throw it out there. I feel like the ESM data is more reliable. I hate to use that word, I don't mean it in any scientific sense. Confident and proficient for identifying which topics are most frequently being practiced, because it's real-time data. It's not me sitting back and thinking about it. So I feel like for the selection of the topics, we should begin with what the ESM data tells us, and then there can be policy decisions as to additional topics that perhaps should be tested or things that maybe should come out. But I think that for the selection of the topics, the ESM data seems better than the traditional survey data. So I'm going to throw that out there as a suggestion.
Could I just ask a question then, following up on that, Leah? So right now they're weighed 50-50, right? When you combine them.
Composite, yes.
Right now. So a question, if we went in that direction, as you suggest, Leah, methodologically, do we just do it in the way you're suggesting, or would one suggest a different weighting in terms of doing the analysis? That's really my question for the experts here.
There's a lot of sausage making in all of the composites we created. If we go with frequency from ESM, in that composite, we can use the frequency standardized scale from ESM, but the others using the average from the other to see how it changes overall ranking in whichever area.
Okay,
Yes.
we've been going for 2 hours, which is about the limit of most people's attention span.
Sorry, what's
that? 2 hours? What? So, and we have a noon to 12:30 lunch scheduled. We didn't get to a couple of the topics that we were going to cover in the morning, but I think we should still take our break. And even though a half an hour is a good, healthy time for a lunch break, I think we should take probably most of that, because we do have some discussion, maybe informally, or at least thinking about the construct statement that we were going to review over lunch. So why don't we break now and then come back at well, let's say 12:20. Does that give everybody enough time? Okay, great, see you then. opportunity over lunch to reflect on the construct and all the other issues we've been addressing, and here is Jim.
So I did update the proposed construct statement. It's on the screen now. I don't know if this is the right time for us to debate that again. We left off just prior to lunch debating which method to use in computing the composites that would rank the different topic areas. And Leah had just said that she thought that the ESM method made the most valid structure for ranking the legal topics. So I don't know which of these things we want to pick up with at the present. I would say we should continue the conversation around how to compute that composite.
Just one thought I have for you and Ron is that, I mean, I get the point of the ESM and the immediacy of the moment and why that might be considered more statistically valid, but do we capture something about the profession's judgment about what's important simply from the traditional survey that you don't get? I mean, doesn't that kind of embody what the profession itself thinks, and should we pay attention to that? You get my point? The traditional survey, of course, reflects what somebody says, okay, I'm looking back and based on my career, what has been important? Does that tell us something that just the ESM doesn't? That's important, and it tells us something that's important, because in some ways it does reflect a professional evaluation on what seems to be important in their life, their professional lives.
We had some discussion at the break about how the traditional response can maybe give us a better gauge on the harm, because there is sort of that 30,000 foot level of not necessarily in the moment, am I worried about my ethics by signing this contract or whatever, but as I think about it over the last 12 months, sort of, where has that, and it's not, obviously there are some instances where the ESM shows a higher rate for harm than others, but I feel like, just what Greg was saying, that at least on the harm piece, that the traditional might give us a little more sort of what I would feel would be kind of a parental look at the bar exam, or something that would give us a little bit more gravitas, I guess, as it relates to that. But I do like Leah's idea about, for frequency at least, I mean, I think that's a really good way to look at it for the ESM, is that that's like literally what they're telling us is how frequently they are.
So one thing that Ron and I talked about during the lunch break was the fact that the rightmost column on the screen now takes into account only harm and frequency. It does it from the traditional survey as well as from the ESM survey, so it's that combination, but it did not include the depth of knowledge question from the ESM survey. We could recompute the composite to include that depth of knowledge. It would then, but we'd then have to decide, relative emphasis of to be given to the two methodologies and the computation. After that, the math works for us, and we'll see what the result is. Criticality is harm. We just changed the name of it to harm for the discussion today because it's only a one-syllable word.
So Jim, that would effectively give more weight to the ESM.
It could, or we could control it so that they're equal in the computation. It's really up to you all to decide that.
Jackie? Oh, no. Yes, Greg.
Neil and I were talking about this a little bit. It strikes me as sort of like deciding what your mix of assets and your retirement outcome would be, bonds and equities. It's weighted 50-50, which is a very reasonable weighting for some people in their portfolio. You could go 60-40, and it really wouldn't change the ultimate result very much. And I think that's particularly here because of the correlation between the two.
what about using the ESM for frequency as was recommended and using the composite or the average for harm and critical depth of knowledge? Or just the traditional survey for harm and depth? I just think for frequency, it just seems to make a lot of sense to use the ESM data.
Agreed. There's no better gauge of frequency than actual frequency.
Yeah.
Does anybody have any objection to running the numbers that way?
I guess my question, I don't have an objection to that, I think that's right, but if we're running the numbers that way, do we need to reconvene, or we're just, I mean, part of this is a little bit like, aren't we still at the end of the day gonna say, should professional responsibility be in there, should employment law, I mean, these questions aren't gonna change which one we use, right? I don't know. We'll just have different data telling us where they rank a little bit higher.
It'll make a difference for those items at the margin. Some of those that repeatedly just comes up on top won't be affected. And those that will be affected at the margin, the question is, where do we set the threshold?
Well, as always happens, it's easy to pick out the top few and the bottom few, and then we're going to have the greatest amount of discussion over those right around the mean or whatever. So why don't we just proceed with trying to figure all that out and then decide if it's critical to choose between a few, whether we need to run the numbers and have another call or something like that. But let's move forward at this point.
So then my understanding of the computation for the composite that we would use to rank is that we would use the frequency and depth of knowledge from the ESM survey and combined with the harm rating from the traditional survey.
Well, I get frequency, I'm not sure I understand depth of knowledge. Why the ESM gives us so much more better than the traditional.
But that's knowledge available only in ESM. Yeah.
Oh, okay,
Yeah.
okay. Oh, that's right, that's right.
We didn't collect that information in the traditional survey because there wasn't an instance for them to make their choice on.
So if that's what you're going to do, but we don't have it here today, what is the closest thing we have here today to that? Is it what you have here somewhere, or is it the data that Ron showed a bit earlier that was just the ESM data, but on all three domains?
So I think it's going to be in your handout. Let me see what I'm looking at here. Oh. Yeah, so let me jump back in. I don't have this, we took it out. I can load up, but can't display it. Okay.
I think page 7 of the Ron handout is what we would need for the frequency, right?
So in the handout, so we decided, I think, that we were going to use attorneys 1, 2, and 3. And so then I think what we're looking at is the data that's reported on page 15 of this handout. And the information that would go into this computation would be on page 15, the ESM harm statistic, and, excuse me, that's not right. The ESM frequency statistic, which is the third column from the right, and the traditional harm statistic. And then we need to decide about depth of knowledge. So what does depth of knowledge bring to the table? that is important for the ranking.
Wouldn't depth of knowledge be more a topic for the test specifications?
Right, but
oh, just when we're talking about depth of knowledge as a value to be considered here, it seems to me that it more properly belongs in the discussions on what the test specification should be.
So it would be the frequency from the ESM and then harm either solely from the traditional survey or the average of harm from ESM and the traditional survey. Right?
well, I mean, it can go either way.
Right.
Right, but you can use one or the other.
Yeah.
Which one would you recommend? Or do you have a recommendation?
Yeah, I don't really have a recommendation. I think that, you know, I mean, the more we begin to combine to build into the formula, the more it's going to look like what we've already computed. Is that what you want?
Well, if the idea is to get a contrast.
No.
Well, to get some contrasting data, then maybe do it the way Lee's just suggested. We think that, and again, that's based on the assumption, we think that ESM is a better test of frequency, and we think that the traditional is a better test of criticality. So is it worth then doing an analysis just based on those two to see if those results vary in a significant way from what we already have?
And if you give me 10 minutes, I can go in the hallway and do that computation right now and bring it back to you.
I'm doing now.
Oh, you are? Okay.
Yeah.
Just on the point, another factor to be considered in our judgment, I don't think we can go wrong either way, frankly, in the big way. But,
I agree.
you know, there are a lot of people will be looking at this maybe with some varying degrees of expertise. And so I would say we should rely heavily on Jim's recommendation on this because he knows the psychometric world and it'll be more readily justifiable. Not that we shouldn't go off the reservation and do something new if we think that's really a good idea for California. I just think that to the extent you can fit within accepted psychometric models, it's probably a good idea for justification.
You are on firm territory with the traditional survey methodology in that regard. It's been used thousands of times, and while there's variations in the scales and so on, it's a generally accepted methodology. The ESM is an exploration into something new. It's given us some fascinating findings, and I think that the community of psychometricians in the credentialing world is going to pay a lot of attention to it. I think you've charted some really great new territory. And I agree with you. I think that it's a direct measure of frequency, and I really love that about it. And I think in some ways the concept around criticality is interesting in the ESM method because it's got a face to it. If the client is a person, I've got a matter and a person who stands to be harmed if I don't do good work. So I like that aspect of it. I'd like, before I rely solely on it, I'd like to see how it plays with other professions and other studies. But it certainly seems to have a lot of potential from the findings that we've gotten in this study.
Yeah, did you?
I just had a question here. Am I seeing this? Is this a typo in terms of ESM harm for environmental land use is negative 3.5?
The mean is 10, standard deviation is 5, so a negative number means that it's a few standard deviations below the mean.
Wow, okay.
That's not an error.
All right.
Glenn, Your Honor, did you?
No,
Oh, okay.
So if you're going to go do some quick calculations, I'm just wondering how the group is going to feel about the competencies. Because right now, so in competencies, we have remind me of the ratings that we have. So we have harm and depth of knowledge only from the ESM, and we decided depth of knowledge is going to come later in sort of test development. So how does the group feel about competencies in terms of how we use the ESM versus the traditional data? Because if they're going to go crunch numbers and we want numbers, we can have them crunched for competencies also.
I think Ron is crunching the numbers right now.
Okay. But does the same principle apply for competencies in terms of frequency and harm, ESM versus traditional data?
So I think the frequency in the ESM methodology is exactly the same. The first question to them was, what are you doing right now? And so that was, this is a direct answer to what they were engaged in at that moment.
I would view it the same. I mean, I also think that there's sort of stepping back and thinking about how much harm can occur on some of these if you're not issue spotting correctly or fact gathering correctly is maybe a better view from kind of a distance perspective than in the moment. Maybe slightly less than thinking about con law as a whole, but because I agree with Jim's point about, if you're in the moment, you've got a person, like, if I really screw up this contract, what's going to happen? I mean, the criticality of that in the moment when you're really looking at it might, but I kind of like the idea that it be tested somewhere else before we use it. So I would say harm, same thing for the competencies.
For what it's worth, I concur with that.
Good enough. So.
I'm working on legal topics.
So what we can do is go back to the construct statement and take a look at the language that we negotiated earlier today, and that gives Ron a little time to do the math.
Hopefully not too much, but
Hopefully not too much time, right? Okay. Yeah, so let me get back to the beginning of this file. And that is the statement as we negotiated it, according to my understanding, when we left the topic earlier today. And so California Bar Examination assesses proficiency in core legal topics and competency areas that are required for the entry-level practice of law and effective ethical representation of clients.
Do you want the grammar police to step in at this
Yeah.
point? Or because since no one's substantively talking about it?
Okay.
All right, so I would take out that R, that's superfluous. And I would say the effective, because that's better English.
And then instead of proficiency, do we want to say assesses ability?
That was suggested earlier. It's not a bad idea. And that it deals with the problem of what exactly is proficiency.
that's consistent with a lot of the other statements we looked at earlier.
Ability is a fine word. So it would be assesses the ability. Oh, no. So the California Bar Examination assesses
Ability. Right. It's
ability.
less of a warranty, right? Because it's, you say, if the test assesses proficiency, then people can say, well, this person is not proficient. But if it tests ability, well, that's a sliding scale, right? It's less of a promise.
It's a pass-fail test, though. And so, I mean, it's either you have the ability or you don't. So is it a assesses the existence of ability. I mean, I don't know. It's
I think that's why we get minimum competency you see in others, as a language that's used in the other construct statements. I mean, I think a lot of bar examiners anyway think about it that way as minimum competency because they really don't care about if somebody's at the top of the chart. It's around the margins that the issue run. And one other point, which is, should we be thinking about adding some language that would address the limitations of what's available given current resources and testability? Maybe that's not in construct statements, but if it's a description of the examination, one of the frequent criticisms is, well, you don't test this even though I do this. And the question is it testable in a reliable way? So if you put a limiting language in there about the current state of the art or with existing resources, at least you can then justify later on if somebody says, how come heck are you not testing, let's call it one of the communicating as because that may not be something that you can test reliably. I don't know, because I've asked that question a few times. Are these testable? And by putting a limiting phrase in there, you might help better describe what the examination actually is, which is this is what it's supposed to do, right? Construct statement.
It is what it's supposed to do.
In a perfect world, we do a lot more.
I like that we're getting away from proficiency somewhat and with ability, but I don't know how you can have ability in core legal topics. So is it a bit like, this is pretty much what Aaron said, like, is it the ability to recall or know? And maybe it's just ability in. I think maybe Judge, that's what you had said. I don't know, or somebody had said, I apologize, ability in core legal topics. But I guess I would say that I sort of go back to my comment before lunch, that using proficiency and competency in the same sentence is a little, I'm just not sure how to rectify that. But one thought is to say that the California Bar Examination assesses competency in core legal topics and areas of skill required for et cetera, et cetera. So if there's some other way to say competency areas or areas of knowledge, skill, and ability or something like that, because I think that's what we're getting at. But I don't know.
Well, I think you could, maybe the language is to go back to what the MD one, the doctor exam had, which was the ability to apply. So you could basically say, assesses the ability to apply core legal topics and competence, and that part would work. I'm not sure you do about competency areas. That's one model that we have, is going back and look at the language of the models we were given. So if we used apply, that would be one way to do it.
So as I understand where we are at present then, it is the California Bar Examination assesses ability to apply core legal topics.
How about core knowledge?
Core knowledge works. But then it leaves us with a problem around competency areas. And so that section of the system that was developed in the practice analysis study really pertains to tasks. But those things are already performed, so application is inherent in them already and doesn't need to be stated. Is there some but I would hesitate to use a word like perform, because then that's going to suggest that this is a performance test. Components of it may be. We haven't designed it, so we don't know. But I'm really reticent about, a word like perform. So got any other ideas?
I think, honestly, my idea is to go back to what's on the screen. Because I think I've done too much here too with my brain of trying to change every single word, and I think just going back to it, like maybe we just go back to it. What you have.
Just like it is, huh?
Rick? I won't die on this hill, but along the lines where you said that less is more, could you eliminate the bullet points and just go with the first sentence, however we
The
want?
bullet points will go. They're just there
Oh.
to draw attention to components of the statement. They go.
Thank you.
So where are we?
So are we back where we started with, except for the editorial changes that were made? So that would take it to what's on the screen, modified slightly to say the California Bar Examination assesses proficiency in core legal topics and competency areas required for the entry-level practice of law and the effective ethical representation of clients.
Can we put in and advising, some phrase that pulls that into? Lawyers don't always act as agents. They often act as advisors.
Maybe it's covered,
All right, just one other question. Instead of competency areas, would and related skills improve anything?
I should stop talking, but my concern about, as you've already picked up, is the testability of some of the skills that we'd like to see lawyers have.
But I'm not sure what that means, because I think that we can probably build anything. It may be cost prohibitive, but I think at this juncture, certainly I would hate to see the efforts of this group be limited by those kinds of constraints. At least as the initial exercise, we should figure out which we should be doing. And then if we find out that's going to cost $25 million, and then there would have to be a reassessment. But I think at this juncture, we should be thinking big, and certainly other areas have much more innovative ways of testing, thinking about medicine, even nursing. The exam is much more progressive. So if they can do it, we should be able to get it done. So,
Yeah, I mean, nursing, you skip your adaptive testing, and if you're out within two hours, then you know you passed, and if you go the whole day, you probably haven't passed. So they ask certain questions along the way to tell them that, well, if the person can answer this correctly, they're likely to know everything else. The advantage is that you don't expose your full item bank and the like. So there are different ways to test. I still think that they're testing core knowledge rather than a lot of nursing skills. Can you turn a patient? Do you have the physical strength to do sort of things? They can't test those things. And I think I appreciate the idea, let's think big, and I think it is a good idea to think big, because otherwise you never really make changes. But as I understand it, we're supposed to make concrete recommendations to the court on what should the current exam be. And if you're not if you have real doubt about the feasibility because of the practicalities of the topic area, then I don't think it helps representation. And what you end up with is the criticism that, well, you said these skills should be tested, but you're not testing it because it's not practical.
I mean, unless we're going to abandon performance exam portions, right? You could always say skill sets, as several people, Emily included, have suggested. I know skill sets is a PC word, right? But it's better than wheelhouses or something like that, right? But competency areas, skill sets, I think it ought to be included. I think it's critical to not just be able to parrot legal interpretations, but to be able to apply them.
Yeah, just to follow up with Greg, the way that I've been thinking about this is what's important for the state bar as a licensing authority to be able to establish that an entry-level attorney is able to know and do. Some of that stuff is going to be scalable in a test that we can provide, but there might be another kind of bucket of things that the state bar might say, we can't test this, but within the first 6 months of practice or within the first year of practice, you must take several educational courses on X, Y, or Z if you didn't emerge from law school with I'll just say a client interviewing course or something like that. So I don't want to limit us because I think we could provide direction to say we think all of this is important. Some of it might only be scalable in a test, and these other things we think are so critical that they should be established in some way within the first 6 months to a year of practice.
Yeah, for example, Georgia has a period, you've got to go through a course of program. In Canada, you have to do articling. Some states have the uniform bar exam, but they say really you also have to do this in order to be admitted, which is typically take a test or even a whole book test on areas of the law that are unique to that state, so people don't run into step on mines that are not generally applicable around the country.
Okay, I think what we should do now is have Jim read whatever he would propose based on all of our conversation is a good construct statement. And if we have general agreement on it, we ought to adopt it at least for the moment and then move on because we've got a lot to get through today. Okay, Jim?
So what I have is the California Bar Examination assesses proficiency in core knowledge and related skills required for the entry-level practice of law and the effective ethical representation of clients. The California Bar Examination assesses proficiency in core knowledge and related skills required for the entry-level practice of law and the effective ethical representation of clients.
I like it. The only question I would ask, would you qualify knowledge with legal? So I really like it, but I think we need to say that.
For legal knowledge?
Legal knowledge.
Anybody object to that? Done.
Good suggestion.
Thank you. Good.
Sorry.
Yes, Mike.
Maybe this is not an issue, but if we modify knowledge with legal, is skills also modified with legal? And if it is, I guess that's fine, but I think there's some skills that are not legal, like time management or something that we would say are still important and could be legal. But is it also, should we say something like professional skills, or, which is a term of art, I know that that is used a lot. So just raise that issue. I don't know the answer.
Sure. So the California Bar Examination assesses proficiency in core legal knowledge and related skills required for the entry-level practice of law and the effective ethical representation of clients.
So would again, I'm not supporting this, I'm asking for clarity. So would you change related and put professional? Is that what your recommendation would be?
I think so, because I don't know that they are related always to legal topics, right? So that's why I would say in professional skills, to make them distinct and equally important to the legal knowledge.
Okay, let's do that and read it one more time, and then we'll go.
So the last reading. The California Bar Examination assesses proficiency in core legal knowledge and professional skills required for the entry-level practice of law and the effective ethical representation of clients.
Everybody good? At least provisionally? Okay, great, let's do it.
I'll press save.
Thank you.
I think there's enough wiggle room on that, depending on how the discussion goes, it all will likely fit within it.
Okay, Jim?
So Ron was doing some computations, probably, how much more time do you need, Ron?
2 minutes.
2 more minutes.
Transferring to PowerPoint then. Yes.
Do you need a memory stick?
Can I ask a question in the meantime? Just, just relating to the number of core subjects that we would say, I mean, if we're not gonna be involved in the conversation of how we test, although sometimes, Jim, you've said, yeah, throw it in there and tell us how you think we should test. But if we're not being involved in that conversation, or that's phase whatever, do we still, though, want to have the conversation of, I mean, for example, if one felt that we should have a sort of stable of topics, you could choose 15 topics like we do now or whatever, and then only test 5, versus we will only really have 10 that students will know of each year. Like, we'll release the 10 topics that possibly could be in January, and then it will be, you know, those 10 will change every year, but we'll have 19 to choose from. You know what I'm saying? Like, that type of stuff. I just don't know if we're involved in that or we let that go.
So others who know the charge to this group better than I should probably answer that. But I do think that part of practice analysis is making decisions about the suite of topics and competencies that should that have the greatest relevance. And I think that it's, and so a plan that might specify which legal topics, and that might be some number, I think
The
currently.
system has detected that a minimum number of lines are connected to this conference. Do you want to continue your meeting? Press 1 to confirm. If there is no response, the conference will end.
So one framework that could come out of this working group, I think, would be to identify some set of topics, probably not all 19, and to say of these, this one, that one, and that one should appear on every version of the test, and the other room on the test would be filled with these other topics following a rotation plan that is randomly determined, so it's not predictable to people who are going to be taking the test. That kind of framework on the legal topic side makes sense to me. But you know, that I think it is quite reasonable for this group to determine what topics have the greatest relevance and to suggest how the framework for the test might go. I think we're going to be looking at the... Well, so Ron has done the computations using the method that we decided just after lunch. And so the ranking based on that computation will help us decide, I think, on this question.
What I created, shown on the slide, is just copying over the original composite ratings. That's the first column. And the second column in red, that's using the frequency from ESM and harm from traditional survey. Yep.
And enlarge a little bit, please.
Doesn't change my rankings. A little bit different numbers. That's helpful. Not in terms of the rankings. It does give you a little bit more understanding of.
So what the ranking was before this computation, based on 1 to 3 years, with the equal contribution of ESM and traditional for all of the rating scales, except for depth of knowledge, was civil procedure, evidence, contracts, professional responsibility, torts, employment, criminal law and procedure, administrative law and procedure, constitutional law, and I'll stop.
I think it's useful in showing that maybe it makes it a little more clear what should be eliminated, like real property, for example, goes down here.
So would we say anything that's 10 or over, de facto should be testable? And if it doesn't hit a score of 10, then it shouldn't be tested, absent an overriding policy consideration? And then there's the question of, I think you all were getting to it, is it tested on every exam, or is it part of a rotation of topics?
With 10 as a cutoff, the only difference between the two lists, you would take out family law from the first, and you would take out constitutional law from the modified rating. The rest, they're all above 10.
Can I ask how, on the topics, and I should know this because I'm sure we've gone over it, but so we've got business associations, finance, security, secured transactions, and tax to some degree that all sort of live in the same, in my world, same realm that I don't want to handle. But if those are small, but all of them somewhat related, is there something that can be used to test the business side, their business law or something? Does that make sense? That I'm just worried that if we are dropping off business associations or corporations or something, that we, that business associations, at least at our school, would, a secured transactions class would probably be in the realm of business certification or something, as would securities or finance. So
also, you are raising the question about the original classification scheme. If they all belong to the same category, the sum of the frequencies would certainly raise the value for those items as a single category.
that's what I'm saying. Are there ways to categorize those business-minded subjects such that maybe it is good to be testing something related to business and corporations? I'm just raising it.
The problem is that opens up the test specifications in ways that might not be fair to the applicants, it seems to me. But, I mean, I could make an argument that real property is so fundamental to the English common law, the way we, certain principles. But what I think the data reflects is that, in fact, most lawyers, minimum entry level, are not doing much real property. Clearly, if they're involved in the kind of practice that Stephen was in, you probably need to know a lot about that, but it doesn't happen until, well, I think this data is interesting on the real property. I can make an argument for real property, but I understand why it comes in a little less than 10.
So a little bit outside the box, but still within this box. If we're going to cut topics, right, the state bar has legal specializations in certain topic areas, right? It exists in family law. It exists in trusts and probates, right? And so we could always tailor something that says, look, we may not be testing for these on the general bar exam, but Californians, we have this advanced specialization certificate, what have you, which shows that these people are competent to practice in that area. So if we're going to start like carving things, much to the chagrin of my colleagues, then maybe we ought to sort of balance that by saying, look, we look to specializations. And so if there's something in the business world that's equivalent, we're talking about excising that from the exam, we ought to have a practice area that's a legal specialization. Just a thought.
There's so many dimensions to this, right? So it means we don't teach. If you go on to 10, you're not teaching constitutional law, and that's an interesting question. Most people, but somehow constitutional law is the foundation of our legal system.
That's what it.
So let's talk. But let's talk about that. Gets the issue of real property, and I think I'm not saying this is a proponent at all. I'm saying that, and I was, before I was a lawyer, I was a historian, so I think in historical terms. The basis of our legal system is grounded in property rights. And that's really, I had to have this conversation with my daughter who hates real property. And many law students do. Why do we teach it? We teach it because it's really the foundation of the Anglo-American legal system. And so that's I struggle over that. I think a lot of academics and others will raise the issue. How can you not test on real property? But I'm not saying that we need to test on real property. But I think those are the kinds of questions that are going to be out there, right?
Well, but to be fair, real property is inclusive of secured transactions, because personal property secured transactions are really de minimis field. And also, to some degree, arguably environmental land use is real property. So you add those numbers up and you're shooting up in the top category. So I think that realistically, unlike trusts where I live and family law where I live sometimes, that's all these areas are real property, and real property is really way up this list based on what I'm seeing here.
Maybe this is where the construct statement is relevant, because what we're trying to make a decision is based on this construct statement for entry-level practice, as opposed to what you earlier talked about based on the construct statement of what a well-educated law student should be.
I have a proposal as a starting point that we would include all of the topics that are at the mean or above. So that would be down through admin law, although I'm open to discussion on admin law itself. But it would include constitutional law and real property for the reasons that we've already discussed. And the others I would not require, not make business law, core topics on the exam. And I put that in the context of, I think we should have about that number of topics that we expect law school graduates to be competent in. Some of them may hit the bar exam 2 out of every 3 years or 3 out of every 4 years, but on a rotating basis, all of the others would be factored in. So law school graduates would study for all of the topics that we're discussing. Now, you could modify that, but that's my general starting point.
So you know how that's going to read, right? How that's going to read is that, hey, Californian lawyers, we're taking out everything relating to estates and trusts and probate. We're taking out everything relating to community property, and we're including employment, and we are including administrative law, because that's exactly how it's going to translate, right? No, family law is I thought family, it's on the cusp. So we're adding one topic to the bar exam. Oh no, because we're taking out corporations and partnerships and
taking out corporations, community property, and trusted estates, and remedies.
So family law is on the lower.
Is 11.4 on the far right.
Right.
So right now there's 13 topics of, right? And this, with Alan's proposal, I think you get 11.
So Alan's
adding in con law and
right.
real property.
As a corollary to con law, can we say constitutional law and privacy? Because it just means more to more people.
So are we taking out admin law and procedure, or are we gonna keep that in?
Well, my original proposal, which is why I threw it on the table, is to leave it in, but that's one of those tweeners to me. Greg?
Well, I think it's a really good starting proposal. I'd argue that you could remove administrative law because so much of it, the principles are embodied in the other topics. I mean, the standards are a little bit different, but evidentiary standards are different, but once you understand the Chevron rule and the like, you may be okay. So I think my general philosophy would be fewer topics is better than a lot of topics, and that So I'd remove it, administrative law, I would include real property, and I would probably include business associations, if for no other reason than the reason the judge said, because people are gonna be really shocked that you don't have some knowledge of corporations and partnerships and like as a fundamental part of knowing what a lawyer ought to be. Even in
Right,
California.
exactly. Graduate from law school and know nothing about business.
Yeah,
That
that's
doesn't-
gonna be a hard sell in terms of credit. In psychometrics, there's such a thing as facial validity, which is, it's just gotta appear generally valid for the population, and so I would include business associations, even though it's farther down the list. And I remove administrative procedure because I think the basic principles are captured in the other topics. I understand the differences, but
Emily?
I would have 6 core topics, I would say, that are always tested, but maybe not, and somebody can decide. But I would say civil procedure, professional responsibility, contracts, torts, evidence, and crim law. And then I would have a second set of 6 that I would rotate, as Jim had mentioned, on exams: employment, admin law, constitutional law, family law, real property, and business associations. Second list is employment law, administrative law, constitutional law, family law, real property, and business associations.
How many of the second 6 would be tested in a given year?
3? I'm making this up, but
So that's our current bar.
Well, you've changed. I mean, so you've cut it down by one subject. And so basically, every year, students would have to prepare for a bar exam, potentially on 12, they'd have to prepare 12 different subjects.
that's right. Although, yes.
Because you wouldn't tell them which of the.
Well,
right.
I mean,
so we're not really cutting back on subjects. We're just basically saying they're different subjects, but you still got to memorize a lot of stuff potentially.
well, I mean, part of it is you've got, if there's 6 that you know are coming up, you have to know them, and students will know that, and then they have to, if I would release before and say, this year, for this administration, we are going to be testing these 3 additional subjects, so that students know going in, they've got 9 subjects they've got to do. Well, Leah, that's up to you.
That was painful, Leah. We could see the pain.
So one question though, is the 10 too low? That's if there's another policy goal of having fewer subjects, the 10 was fairly arbitrarily selected.
I'm wondering whether the standards there could be.
Depends to me. Depends to me. And I'll just remind you the point I made earlier about the standard deviation. Plus or minus includes 2/3. So -1 standard deviation is still relevant. Tough.
I assume that what's driving our decision on what topics to include in the list that may be tested is not how many topics the law students have to prepare for, or the exam takers have to prepare for, but what we think is necessary for a entry-level person to be competent in various subject matters. Right?
yeah, I think that's exactly right, and yeah, the question is, what should students on the topics know to be able to be minimally competent to practice law as an entry-level lawyer, not how many studies they have. But my point on the fewer, in my view, fewer topics that you can end up with, the better, because, and I would make that distinction on which of the topics do you think that the fundamental kinds of thinking and reasoning appears elsewhere. So, and that goes along with Steve's point about the real property is fundamental to property rights, fundamental to the American jurisprudential system. So, well, I'm repeating myself now.
Jack.
Just a quick, just so I can understand people's rationale in between having 6, 9, 12 topics available. What's the rationale between more versus less? Is it a worry about what people emerge from law school kind of having taken? What's the rationale behind it? Just trying to get.
Steve. Okay, I think one of the issues with the current bar exam, which involves a lot of memorization, is that, and there have been studies like Deborah Merritt's, which is by adding topics, it's just become harder to memorize the basic information that is necessary to pass. Okay, now, okay, let's have 12 subjects and have an open book bar exam. Question mark, right? But I think some of us have been thinking that the idea of a core set of subjects is that what you're really trying to do is to get people, is to show they have the analytical skills to apply law to facts. And you don't need to test on 12 separate, or have students prepared to be tested on 12 separate areas of law to be able to test that. That's where I see the disconnect. I think there's a consequence, again, I think it's wonderful how there are going to be new testing skills and things like that. We should probably maybe just keep this separate and say, we're going to fundamentally think of how testing is going to be done, because it's not going to be memorization 12 subjects, even if we say we're going to test on 12 subjects. Then I think this is the right conversation. But if, in fact, it's okay, it's going to be as it is now, and people have to memorize a lot of subjects, then I think there's the potential that that process of memorizing the rules, the law for 12 subjects, will be an obstacle to seeing if people have the ability to show the skills that we're also trying to test. I hope that makes sense. That's the point I'm trying. I hope.
Well,
Can I just go back to Neil's question about standard deviation? I'm just wondering, Ron or Dr. Henderson, if you can guide us here. If you were going to, so you've got admin law is 10.1, and then you've got civil procedure 20.4. But between them, those are sort of clustered, right? How should we read that? Is there, obviously if you were going to test on one subject, it would be civil procedure, that's clear, right? But beyond that, how should we look at that cluster between professional responsibility and administrative law?
Well, I don't know anything about the law, so I don't know what goes together and what clusters are not. So the standard deviation would, one standard deviation from the mean in this setup here would, so what happens to a standard deviation when you combine?
Ron's, except that doesn't have the traditional harm rating.
So
the interpretation is the same.
Data.
So, but civil procedures above a standard deviation above the mean. Professional responsibility all the way down through legislation and government are within a standard deviation of the mean. So, I think that gives probably too many topics to consider for the test.
So like professional responsibility contracts, torts, those are close to being more than one standard deviation above.
I think you and I are reading on the same sheet of music, Stephen. I think that the kind of things you're trying to capture is the legal reasoning. I think memorization gets a bit of a bad rap, but I can see why having too much memorization for these and buying much more for you in terms of the analysis of whether the person can reason legally. And the topics that capture those kind of concepts that apply across the law generally are the ones you should hone in on. So that's why torts, all right, that's civil wrongs, and the contracts is agreements, evidence is relevancy and all that, and how we do this related to procedure, we get all those. And that's why I think we can be comfortable eliminating some of the other ones that are farther down the scale, because really, if you think about it, that core at the top pretty much grabs it all otherwise. The kind of reasoning skills that people need to have. And I haven't thought through it in terms of the concepts, but those are different areas of law because each one of them has a special kind of fundamental rules and application of reasoning, legal reasoning. And that actually translates over into the others that are at the bottom of the scale.
Maybe in reviewing the list of the legal topics, it's helpful also to just look at the ranking of the competency areas. Because when you look at competency, it is telling you, regardless what you select from this, it is where they actually use it and how they use it that's relevant.
So for example, secure transaction, which is the bottom scale, we're back on that, but secure transactions, well, that's all in real property and contract. You know, those two topics cover secure transactions.
So, while I completely respect the scientific nature of all this, I guess because I was an elected official for so long, there's still a political issue here that I'm trying to tackle, and that is, so I teach trusts and probate to judges, right? I teach orientation courses. I teach judges in elder abuse. I teach judges advanced trusts and probates. If it comes off the list, I have to explain why. And standard deviation issues is not going to work. But if I tell them, okay, it's a specialty, right? There's a legal specialization. That's a good way politically to say, okay, fine, it's coming off the bar exam, but it really is there. If you want to hold yourself out as having expertise in this area, you take the specialization exam. The same can hold true for family law. Some of these other areas, there's going to be so much pushback by eliminating topics that just by acclamation, if we just use the numbers to resolve these issues, it's going to be problematic. I mean, that's my thought.
Emily, did you have?
I just wanted to, oh, my mic's on. I wanted to respond to Jackie's question too about why the number of topics, because I do think that is important. So when I look at our charge or our construct, now that we've developed it, and we have proficiency in core legal knowledge separated from professional skills, the skill of sort of showing that you can analyze and do factual analysis and legal analysis is a big skill tested on the essays as far as that's concerned. And I think once you've done that with an essay or two, you don't need to do it with so many. So I would say, I mean, I had proposed, sort of having 6 always subjects and then 3 rotating. I think that wreaks havoc, honestly, as I think about it for law schools. So I'm not really a fan of that plan so much for that. But I do think that if we think about what core legal knowledge is, I think we can all debate on the margins. But I do think that there are some that it's hard to debate that civil procedure and professional responsibility and contracts and torts, I mean, even if it's just those 4, right? I think people could say constitutional law, of course, or crim. But I do think maybe the idea, and this is getting to Jackie's point, is that maybe there is a big shrinking that should happen on what core legal knowledge is, and maybe an expansion of what professional skills are being tested. So.
But if we have 5 essays on the bar exam now, I don't know, maybe pick 10 legal topics, I'm assuming, versus the 6, since we only have 5 essays, and then the rotating 3. I mean, of course, you can test more than one legal topic on a given essay. So we're not going to have 5 are we determining the number of essays or the performance tests right now, or?
Well, the test can be redesigned as a result of this process. So that shouldn't, dictate your thinking around number of topics.
Robert?
I want to echo what the dean said. I like the idea of reducing the current number of topics for lots of reasons. I think it says that we're getting what this is not a memorization test. This is an issue spotting and analysis test, and by limiting the areas to the core, I have 8. Civ Pro, contracts, real property, torts, criminal law, evidence, and contracts. All, how many will be on the bar, but those are the ones that you need to prepare for. I don't like the rotating idea. I just like these are the topics, but instead of, what's our current number, 14? 13, then we would have 8, and I think that says a lot about where the bar's focus is, analysis, issue spotting, the kind of things that got the highest ratings in what people do that answered our survey. So I like the idea of getting down to under 10. Like I said, the 8 on my list I think are the core ones. Civ Pro, con law, real property, torts, criminal law, evidence, and contracts. I've left professional responsibility off because I thought that might be something that could be handled in law school. Leah had some ideas in that area.
What I was mentioning is we already have a new attorney 10 hours of MCLE that's required within the first year practice, and you could incorporate a professional responsibility course there. Since students already have to take and pass the MPRE for admission, so you're sort of safe there as long as you're comfortable with the MPRE, and then within that first year of practice, you could have a professional responsibility exam. It would be administered all online. You have to achieve a certain score, or there could be like an administrative suspension process. So you could handle professional responsibility separate from the bar exam. I think there's certainly models for that, and it wouldn't be difficult for us to do.
That's exactly right. And the topics that Robert just stated, the 8 topics, so it's 7 less the professional responsibility. Because the multi-state bar exam, right, which people are going to have to study for because they got to take it, right? Contracts, con law, crim law, civil procedure, evidence, real property, and torts. So if they're studying for that anyway, and we're talking about those exact same topics, maybe we should synchronize ourselves to the rest of the country if that's the discussion.
Responsibility required to be on the bar exam as one of the essay topics. That was something that the Supreme Court had expressed that requirement. And so I think we have to have a buy-in from the Supreme Court to take that off. I think to take that off of the exam, and also to the extent that we are going to keep, and obviously we don't, we're not constrained by that. But the MBE, there are 7 topics on that the applicants would have to study for anyway. So that's, if we only have 8 topics, then that's one that they won't be necessarily studying for the MBE, but just to keep in mind.
That I said the 7 on the MBE plus 1 more.
The MBE has civil procedure, contracts, torts, evidence, crim law and procedure, constitutional law,
Real property.
That's 7.
Right, and there's a multi-state essay exam, which has a whole lot more.
Yeah.
Includes business associations, conflict of laws, family law, trust and estates, and UCC.
But we don't administer right now, we don't administer the multi-state essay exam. We
Then
have our own essay.
I'm wrong. My number is 7, not 8. Criminal and crim procedure are 1.
Yeah.
So then mine is 7 plus professional responsibility, as Leah suggested, maybe to be tested elsewhere in the law school or graduate time. So I'm at 7 topics. So that's literally half the topics that we currently test. Because
We test 13 currently,
so a little bit, from 13 to 7 on my only misgiving is that on my list, I eliminate topics that are unique to California that, part of what make it the California bar exam, subjects that are not tested or in other states. But I think to match our mission statement, following what the dean was saying, I like the idea of making these core subjects and then honing in on the skills that people use that we are testing. Can you spot these issues and do an analysis of them? We're giving people more opportunities to succeed within these topics without changing the way we, rate the bar.
And what's the rationale for excluding employment, even though it came up relatively high? Is it because of this policy decision to have fewer subjects and it's not as sort of substantive as a distinct subject as these others that we're talking about?
I will say for me, yes. I think for when we look at core legal knowledge, I practiced employment law for 6 years, and I took a lot of what I learned with my core legal knowledge and applied it, because it does pick a lot of other things. But I also think that I would be more interested in knowing how the NCBE may come out on employment law and maybe other states, because if employment law is really specific to our folks, I think that's good to know. I just don't know that. And if employment law is, that there are out-of-state people in other states that would want to come practice here, and we would say, well, knowing employment law is important to practice here, that's a policy decision. But if we're really just talking core legal knowledge without specific to California in our sort of construct statement, then I would say I don't know enough about employment law and what data we found to know if it's really California or if it's now become core legal knowledge.
I'd say it's twofold. There's not something particularly unique about employment law in terms of the legal principles and rationales that are applied. It's actually embodied in the other topics. That's why, I would suggest it. That's why the exercise of judgment that Dr. Henderson talked about, what you could do, what you add in, not based on your professional judgment, what knowledge is appropriate. On the professional responsibility matter, you know your court better than I do, but you now require the MPRE, which is basically testing whether people have familiarity with the professional rules generally. It obviously doesn't have the particular California rules, but generally that's the point. But people don't generally understand that scale. That scale is a whole different thing than the MBE. So I don't know what your minimum passing score in California is for the MPRE, but it is a fact that nationally most states have way lower minimum passing score than they would on the their bar exam generally combined with the MBE. But I think professional responsibility can be a separate one. I have a sense that the court may have said, and professional responsibility is really important. That's why we're on it, why it's on there. But that's what this group is to think about. Okay, but really, what we're talking about, what should court be on the exam aside from the MPRE? This is what we ought to include. But that goes to the politics you were talking about, which is not insignificant.
Just a question. So, family law is on an essay question for the UBE. Greg, do you know why family law is there? It must be a protection issue?
No, it's not a protection issue. I think it's because, this is Greg Murphy talking now, not the NCB again, just reemphasize. I think it's because it's a facial validity issue. Gee, there's so many people doing family law, therefore you ought to test on the bar exam. And, I think that's why, and so in order to have it saleable, I suppose, to a lot of jurisdictions, most jurisdictions would say, gee, we have a lot of people practicing family law, we ought to test on the exam. But this would,
because I wanted to go back to the employment law issue. So I think that really is a lot of that California specific. So I teach a course in the spring called In-House Corporate Counseling, which I teach with the ACC. And the two people who come in, because we talk about overall professional responsibility issues, different roles, but then areas of particular concern in in-house counsel. And the people who come in and teach labor and employment do nationwide employment for Petco and Best Buy. They happen to be here in California, but I don't think either one of them is actually a California lawyer, but they both do They head employment nationwide for those two nationwide companies. And what they tell our students over and over again, that the overwhelming majority of the issues they deal with relate to California. That the California employment law, all the wage and labor, and that is so different and so complicated and all of that, that it vastly outweighs anything else. So that's the issue about employment law. I think it really is. California employment law is very complicated. There are all kinds of rights and remedies that don't exist in other states. And so it's a very important topic in this state. Does that mean it should be tested as part of the standard bar exam, or does it mean that there should be some specialized testing for specialists, or even something which says that once you pass the bar exam, you should do some online, as New York does, in strong areas of New York law? I think all of those issues should be on the table. All those possibilities should be.
Or it's a requirement for admission or to be eligible to take the bar exam that you've taken and passed a California employment law course in law school. That's
another great
way to
option.
do it.
Yeah, I don't know California employment law except at face value, everything you say, so, you know. Yeah, and that would be, well, I think the better process is to deal with a separate issue like a lot of states do with the UBE. They say that we have, this area is so important to us that we're gonna, or these rules of law, you need to know about them, and that would be appropriate. Or as Leah says, just put it as a requirement for the bar exam, and then trust that they've done it.
All right. I'm going to insert myself here for just a moment. Robert, Robert, there you are. I really liked your 7. Professional responsibility certainly can be discussed separately, whether to be on the bar or tested otherwise, but I don't think there's any doubt that we need to make sure that people are well aware of the Code of Professional Responsibility and so forth. There are 2 other areas that I think we should consider. One is employment and the other is community property, because part of our licensing exam here is to have a level of confidence that a recent bar admittee, just having passed the bar and the moral character and so forth and so on, who goes off to opens a solo practice in a small town without much backup, has enough familiarity with certain areas, especially those that are peculiar to California. There's no other reason to have a California State Bar exam unless we're testing things that California lawyers particularly need to know, including all the normal things. But so I want us to think about that, not just from the standpoint of how many subject matters we are going to test for, but are there a couple, or are there any that really do need specific testing because of the unique California law? The other one is business associations, and it does seem to me that there's a basic requirement for understanding various forms of joint venture and corporations and so forth and so on, that a first-year solo practitioner in a small town, which is my paradigm, might need to know. We could discuss all of those 3, but Jim has a suggestion for how to proceed at this point. I think it's a good one, and this might help start us moving through the process. So having preempted the conversation for just a moment, I'll turn it over to Jim.
So I do have a suggested plan, before I unveil it, let me just remind you that the practice analysis data tell us what's really relevant in the minds of the people who are practicing in their first 3 years. And that is the primary consideration that you should have in making these decisions. What happens in law schools is of secondary importance. What happens when people study to take the bar is probably of tertiary importance. Keep in mind, the data that we have provide the best rationale for the content framework that we end up with, as long as you apply what the data mean to the discussion. And so my suggestion is that I haven't heard anyone, I want to eliminate. And I didn't touch it at all. So I want to eliminate rather than decide, so that we get some stuff off the table and we're holding just a handful of cards rather than the whole deck. So I'm going to suggest that I have not heard anyone make a case for the bottom 5: finance, tax, legislation, government, securities, secured tax. I'm going to suggest that we take those off the table. Not hearing any disagreement. They're gone. 1, 2, 3, 4, 5. Okay, those are gone. All right, so I'm going to start at the top then, and we'll alternate back and forth. So civil procedure, sounds like it's an automatic in. Any disagreement?
Well, if you're eliminating first, I haven't heard any real strong advocating for remedies, which is, that's on the bar now, right? Can't we say that's sort of grouped into contracts and torts and other, at any rate, if we're eliminating first, I haven't heard that on anyone's list today, so.
So remedies is not per se on our list. It's apparently dealt with other topics that are in some combination.
Well, I think we made a decision not to specifically identify it, but it is one of the current subjects tested on the bar. I think we decided it was encompassed within other subjects, but.
It is, it's cross-disciplinary, right? It's just.
Yeah, but if you want to do a little hatcheting right now, that's one, I think.
So, okay, so. Right.
Okay.
All right, so civil procedures is in. All right, so then business associations.
If it's not going to be on the bar exam, you got to require it in law school. I mean, you can't put a shingle out and not have business courses that you've passed. It's just ludicrous.
Here's a question, Dean-like. If it's not on the bar exam, for example, community property, would no one take it? Or would very few take it? I only took it in law school because it was on the bar exam. I had no interest in practicing family law, and I would never have taken it otherwise, but I'm sure that was how everyone in my law school felt. We had to take the subjects that were going to be tested. And I'm none the worse for wear. It was actually a great class and a great teacher, but I wonder what that would do to those classes if they weren't on the bar exam. And do we care about that? Or do you, as a dean, do you care about that? Business, corporations, the kind of things that aren't on my list that I probably might not, I would have taken something else.
So I'm not supposed to say what happened at this meeting we had a couple of weeks ago with the Supreme Court, but I will tell you it's a general consensus that's been, and it's articulated to the justices among the ABA deans, that too much course selection in law school is being driven by the California bar exam, and that is putting us at a competitive disadvantage to law schools in other states. So that gets to the following point. I think that our concern is there are too many subjects that are tested, and that's negatively impacting the ability of students to prepare for legal practice in the specialized world in which we are. Yes, so that is driving behavior. So then I asked the question, which, and again, I think what Leah suggested sort of makes sense, but does that mean that now California would have different requirements than the, for example, the ABA has? So I don't think we have that right now. We don't say as a state, we could, I'm not saying I'm saying we could, I'm just asking the question, that California could basically say, we're doing something different with the bar exam, but what we're going to say is, in order to be certified to take the bar exam, you have to have taken the following courses. I think that's what you're potentially. I'm not questioning it. I think it might be a very good way to go. But that's one of the things that you think should be on the table.
I just think there's a lot of different paths or
Yeah.
avenues for addressing the myriad of interests that we're all articulating. And so I think that is one pathway, and that's well within the Supreme Court's purview to set that as an eligibility requirement. And then, of course, on post-exam, we already have the infrastructure in place for this required 10 hours of new attorney MCLE, all online, very easily adapted to a testing format for professional responsibility, for example. So we have more available to us than perhaps we've taken advantage of in the past.
So again, I would just say, I want to get back to your question. I really do think it's worth thinking in those terms. But I think that if what came out of this was we have a bar exam which is somewhat fewer topics, but then we had something like that, then I think those of us on the ABA side will continue to be concerned that basically too much is being driven by licensing and too little being driven by preparing people for the kind of careers they're likely to pursue. And that's one of the challenges that we see. Does that answer your question? Yes.
I would never avoid that. So you're really deciding, especially pretty early on.
But I think that this comment was made, and I'm going to quote it verbatim, that what's being driven right now is that more people are taking remedies and wills and trusts than are taking tax. And there'd be an argument that I think all of us would make from the point of view, many of us would make is people understand the legal profession that tax is probably more valuable in terms of preparing, whether you're a litigator, a transactional attorney, a family lawyer, or anything else. So, yeah.
I would just add, if I may, that I think too that, I would just be cautious about putting anything on California law schools requiring different courses, because you do have a lot of students coming from out of state that are going to go back and take their home state's bar. And if they are, I think it's putting, and again, I know the bar wants to do what the bar wants to do, but just as far as the competitive advantage that we have for law schools about, having people come to our law school that may be sitting for other bars. So I worry that if it's business associations and marital property and all of this are required, that still hamstrings law schools in some way.
But Emily, it doesn't have to be a requirement for law school graduation. It just needs to be a requirement to take the California bar. So a passing score in these courses.
Yeah, but unfortunately, a lot of students don't know if they're going to take California until they're thinking I'm going to go home, and then all of a sudden they wake up and they're like, oh my gosh, I have to take, I'm going to take California. I'm going to be living here. Now I have to take those classes.
Good. They can take them.
But then if somebody graduates from law school, do they have to come back and take a class? Do they have to get certified in a business associations class from a law school? I mean, I'm not saying don't do it. I'm just saying, think about it before you add a bunch of classes.
I just think once we start excising topics that thousands, maybe tens of thousands of California lawyers are practicing, we're gonna have a revolution on our hands. So if we can ease the pain by saying, this is still an important topic, and if you want to sit for the California bar, you need to have a passing score in law school. Then at least, walk into the law office, right? You're opening up, you put your shingle out, the client comes in and says, can you write me a trust, right? You're just gonna go online and just copy what's on Google, what are you gonna do, right? So you have to have some level of competence.
Yeah,
Right.
I don't disagree with that. I think New York has done a good job of, there's a lot of things I don't like about how New York handles their bar. Sorry,
well,
that's
everybody
all
passes,
public
yeah.
now. But I do think that they have an online exam that students can take before the actual bar exam that is New York-based law, right? So you could go on and take, if you wanted to, take business associations. It's all open book, but they have to take a class on it. Then they take the New York stuff. So I would
that's an
just
option.
say
There's a lot of states that have their local.
that might be a better way to go. Anyway, we're not supposed to be talking about testing, but there we are.
Well, just reminds what Dr. Henderson told us, that with respect to the issue of whether, it's helpful or not helpful to law schools is not the question. And this is somebody who's been involved in law school accreditation, so I understand the issues, but for license examination, that's not supposed to be, we're supposed to be focused on. It's protection of the public.
Jackie?
Yeah, just a quick note on that. It seems to me it's been exciting to get this information, not just for purposes of determining the future of the bar exam, but really helping our students graduate as skilled, competent, and ethical attorneys who will be prepared to practice in California, because that's where our students practice. They're only eligible to sit for our bar. Being able to craft a curriculum that certainly helps them jump through the hoop of the bar exam is one step of it, but I always tell them that your ultimate goal is to be a skilled, competent, ethical attorney. So even if we don't test on employment law or business associations or administrative practice and procedure, I would want to incorporate those into our curriculum because I see them as important skill-wise. And it could be that an individual school makes it a requirement, even if the bar doesn't, because we perceive that it's important for our students to have that base knowledge. Or it could be that the bar incorporates it into a licensing program as well. But I want to distinguish between how are we going to test for that proficiency versus what someone needs to be a truly skilled, competent, and ethical entry level attorney. I don't think we can test for all of what's necessary, so we're going to have to figure out a middle ground.
I agree, and thank you. This is a very important kind of policy issue that we're wrestling with here. On the other hand, we only have an hour, unless everybody wants to stay over and change their travel plans and so forth. So what I'd like to do is go through, and if we have a topic like business administrations, let's just put it to the side for a minute. Let's put a question mark by it and then move on, see how much we can narrow the topics that we're talking about. I don't want to cut off anybody because this is important, but I just want to remind everybody that we do need to kind of move this along as best we can. So if we get through with it, we do, and if we don't, we'll figure out what we're going to do. There we are. Okay.
Is there any way we could see the list in real time? Just take the subjects and as we eliminate them, put question marks next to it?
That would require somebody at the machine to keep up with us on this. So I've got a question mark by business association. We did not take it off the table. We did not make a decision to include it. So let's go back up to the top of the list for professional responsibility. And my understanding of that is that we may be able to address professional responsibility as a topic area in some way other than the bar exam. But that's an open question. I think the court is looking to this group to make a recommendation. Is it the recommendation of the group not to test professional responsibility per se on the test, instead to require some other activity in the first year of practice with an assessment requirement at the end?
Well, remember, they're already taking the multi-state professional responsibility examination. That's an important thing to mention to them. I mean, the court wants to say, well, we want to know in the context of your California questions, are the ethical issues being addressed? And I think you can test it separately, but that's.
You've stated it properly, that is something that may be addressed elsewhere besides the bar exam, so we can keep moving.
Yeah.
I just say I'm strongly opposed to it. I think you absolutely should test professional responsibility as many times as you possibly can, because I think it's a huge problem. So I would leave it as a recommendation to the court. If they want to take it off, they can, but I like Robert's list plus PR. Sorry, Neil.
And to sort of to jump on that last point that Emily just made, I mean, as long as professional responsibility is still tested in some way, whether that's shifted out of this exam and into something else, I don't think the court would have an issue with it, but that's something I'm speaking just on my own behalf.
So then we make a recommendation to the court that we explore other ways to test other than on the bar exam, but if nothing appropriate is arrived at, we leave it on.
So then jumping back down to the bottom of the list, environment and land use. Off. Back to the top, contracts. In. Back to the bottom. Hate to ask, real property. N. Anyone think that we should leave it out? N. Back to the top, torts. Back to the bottom, estate, probates, and will. Out?
Ooh, I want a quid pro quo, whether it's whether it's Emily's open book exam or whether it's Leah's law school course. You can't have people go into praxis and know nothing about estate planning, having people walk in their doors, because they're going to hold themselves out as competent. They're not going to say, go away. They're not getting any work, right? They're going to say, come on in. I'll write you a charitable remainder uni trust.
Okay. On hold.
All right, so that one we'll debate later. Evidence. N. Okay. Constitutional law. N. Anybody think that it should not be in?
And privacy.
Employment.
On privacy, we can tell by looking at the subtopics whether privacy was included in con law.
Right, and I can pull that up in just a second.
Okay.
The system has detected that a minimum number of lines are connected to this conference. Do you want to continue your meeting? Press 1 to confirm. If there is no response, the conference will end.
Employment is my practice area, and I'm voting out, so.
I agree.
So times change, and practice areas change, and it's hugely complicated. It's got tons of California lawyers who are engaged in it. If we do Emily's California special exam, that's one thing, right? But if we're not going to do that, then let's show the public that we're actually, A, reading what the lawyers are telling us, and B, we're actually malleable or flexible enough to move with the times. Why do we have to go back to 1870? I don't get it.
So I noted for employment and the state's trust, maybe there's another way of testing, which is euphemistic for if it's through specialization, if it's through a law school course, eligibility, whatever, that you have some discussion about those things. That's why they're red, but not the green is in the exam. That's this color code.
Well, this gets down to me the nub of the issue. Are we testing so that the hypothetical brand new attorney who goes to this small town with very little legal backup and support is able to competently serve the people who walk into his office or her office, in which case I would say employment law should be in. Or are we trying to restrict this to kind of core courses that you can learn off of? It's a pretty close call. I would go with including it in the exam, but you can argue it either way. But in any event, I think it should be one of those. Actually, I'll defer to the Supreme Court.
Not the Supreme Court. I just communicate. Anyway, I'm just thinking out loud. What if we had, for these kinds of issues, whether there's a concern that the test taker is going to practice employment law or practice estates and trust in California, what if you just had an optional component of the bar exam in which the applicant could specify, I plan on going into this area, so test me on it?
But is it a requirement to practice in that area? Because that would be specialty practice exams, which we don't do now, as a requirement to practice.
Again, I'm just thinking out loud.
Yeah, the other issue is the whole issue of how you combine with standardized examination. And what would that do to it? I don't think you could do it, but
That would introduce a bunch of equating issues, and the license needs to communicate the same thing about everyone who holds it. So I think everybody has to take a test that's drawn and following a plan from the same outline.
Jackie?
Just in terms of employment and some of the other ones that are higher up but we're potentially eliminating, I'm comfortable saying that there's things that are lower down, but in our professional judgment, we think that they should be tested. I'm less comfortable saying this attorney surveyed have told us X, but in our professional judgment, we've decided X isn't that important. So I'm more comfortable adding in a subject like con law than I am removing a subject that we've been told is a part of a new attorney's kind of portfolio.
I think we should be testing on employment.
That's what we're being told.
And I think the question is, are the kinds of knowledge and skills that you have on the other topics, particularly knowledge, and cover the fact that you can go research, as Steve says, is that sufficient to say we really don't need employment for competency? You know more about California employment law than I do, so you're judging me better on that. But my question is, we're talking minimum competency here, and we have an employment lawyer saying no.
Well, and you know, Jackie, I say I'm not as uncomfortable removing topics that maybe got a high score. I mean, we're being mindful of, we want to make this less of a memorization test. I mean, that's one of my goals in reducing. I guess even as a labor judge, an employment lawyer, I like to think that the things that we're going to be testing, issue spotting, analysis, lend themselves to learning a new area. If somebody comes into your small practice and says, my employer is not paying me, you have demonstrated minimum competence to do research and analyze the law. You're going to have to do that for a million things. Can I get a fishing license? I just caught a fish. Am I in trouble? I mean, that's something no one would know anything about until they do it. But if they've mastered what we have defined as minimum competence, the ability to read a set of facts in any subject, analyze those facts and draw some thoughtful conclusions, that's what you do on the bar exam. Well, then if you can master those skills, I think you can attempt to master them in areas that you're not tested on, whether it's drawing up a will for someone or someone who says I was wrongfully terminated. We're hoping the skills that they've demonstrated proficiency in will serve them in doing research and applying that research to the facts of their client. That's why I'm voting no on my own practice. So not to be a wet blanket about employment and family law and wills and trusts, but I think you'd have to figure it out or know to refer to somebody that does it, which would probably be the smart thing to do.
So I'm going to record undecided on employment because I haven't heard consensus in the group. We'll come back to that and have more fun. So down back to the bottom, administrative law and procedure, in or out?
Out.
Any disagreement on that? Okay, criminal law and procedure. In. Any disagreement? Okay, so then that leaves us family law.
Out. Divorce.
Okay, so then we have questions about several areas. They are business associations, estate probate, or what is this? Estate trust and probate, thank you, and employment. And then professional responsibility.
Estate trust and probate, Judge, your feeling, I think you're okay with taking it off the bar exam as long as there's some other place that there is a responsibility for learning the material
Right.
housed.
And actually, it should be treated as like kind with the family law. And I know it was removed from the list, but really, what happened, because there's a specialty, legal specialization already in California for probate, there's a legal specialization for family law. I know these groups, they're, you know, they take an exam, they hold themselves out as experts. We just, the state bar, not we, y'all, need to take greater efforts to let people know that in these categories, that is really the sine qua non of competence.
I haven't talked much about the UB here, and I'm not here to sell it or whatever, but I just will note that trust and estates and family law is on part of the UBE. And one advantage that it would give you if you did it is that you would be able, the people who didn't achieve a minimum passing score could effectively transfer to elsewhere and be admitted. And that would take some pressure off of some of the issues that you face.
So I'm hearing consensus emerging that estates, trusts, and probates coming off. Okay, so then I guess we have business association and employment law still that we have question marks by. So let's take business associations. In or out?
In.
Out.
No, but appreciate when right, but even in areas you practice, right, it's all about businesses. I mean, the labor is about business. If you don't have a fundamental understanding of business, you can't do anything in California except, I mean, even contracts are most often between businesses. Right, but I've heard this, like, don't load up our law students and inhibit them from going to Missouri.
Well,
I'm sorry. I don't mean to diminish it. It is.
So we're going to go around the room, and gee whiz, I don't know where to start. But
I'm sorry. Can I get like I'm on the fence on the business associations. I don't know what's the pro and what's the con. Have we already done that? And I should.
So some justification. Let's hear one justification for in and one justification for out.
Well, the justification for out is that one of our goals, at least right now, is to have fewer topics on the bar exam, to make it less of a memorization test with more of a focus on analyzing issues in core subjects. And the subjects we picked as the super core ones are the ones that most people take in their first year or year and a half of law school. So I'm kind of eliminating all of the classes outside of that are more specialized, I suppose, which is where I put business associations. I have no problem making that part of a core curriculum in a law school. And I wish that we could say for sure that we're going to do something like that, because that would make everybody less uncomfortable about removing it.
So that's the argument.
That's my con. That's my remove argument.
That's the argument for taking it out.
So, business lawyer, most of what I did was advising corporations on corporate governance. It's foundational for anybody who does this. I suggest we take it out for the reason you talk about. Now, we're going to get the argument that people are going to go to Central Valley, those 2 to 3% that go straight into practice, and they're going to form corporations. If we're concerned about that for public protection, then I'm going to strongly suggest the state bar ban legal.zoom, because most of the people out in the Central Valley that are forming corporations are basically going to legal.zoom, taking up a partnership or articles or bylaws or LLC agreement and filing them on their own. That's what's going on. Okay, so I'm, the individual clients are they're worse than having uneducated lawyers. So I don't think that you need corporations to protect the public. And I don't think you need to require people to be tested on the exam. They're going to be corporate lawyers, but it's going to do it. So in the interest, for the reasons you articulate, let's get down to subjects that are the core. I would say, and this, by the way, it probably means that when I start teaching corporations, I'm going to have many few students in my class, but that's okay. I think it's the right thing to do.
Well, thanks for making the pro argument there, Steve. Your Honor?
So the argument is, guess what? I'm going to law school. That's the good news. The bad news is I'm going to graduate from law school and not know a single thing about business because I don't have to, because it's not tested, and I'm going to be a lawyer. I don't know anything at all about business. I don't know about business entities. I don't know about business transactions. I don't know what an LLC is. I don't know what a partnership is. I don't know what a corporation is. And guess what? I don't care. So that's the argument for keeping it in. But I also think it is one of those areas that we ought to, if it's going to come out, which I understand the logic, then it needs to be covered somewhere else as a requirement, not an elective. It's just business. You can't go to law school and not know something. I don't care how fundamental it is about business, period. Right.
Okay. What?
I just want to say one thing about that to the judge.
So much for our 1-on-1. Go ahead.
Okay, all right, then it's okay.
No,
I just want, there are so many subjects that I did not take in law school that I don't know anything about. Certainly I didn't then. Water law, intellectual property. I mean, there were a zillion things that when I got out, people asked me, what about this? What about that? I don't know. I didn't take that in law school. So
right, but that, that's the ethics side of it, right? Because you said, I don't know anything about this. Go down the street to XYZ law firm. But when we're talking about first-year lawyers who are not in big law firms, which is a lot of them, take Ventura Law College, for example, Santa Barbara Law College, they're not going to join big firms. They have to hang out their shingle. And they're not going to send people down the street because they need to feed their family. So that's a big, and I know Donna's down there being very quiet, but she's in charge of professional or discipline in the state, right? I mean, what do you think about all this?
But Judge, is your pro argument, is the essence of your pro argument that if we keep it on the bar exam, we will force everyone to take it in law school? Is that of your?
No, I think we need to force everyone to take it in law school. I don't think it needs to be on the bar exam, but by saying we're just going to put it in a different category right now, I'm uncomfortable with that.
Okay, I'm going to insert myself and make a very quick comment. I think these topics fall within several different buckets. The most important bucket are the fundamental and foundational ways of understanding law. Torts, negligence, duty, et cetera, contracts, consideration and acceptance and so forth and so on. All of that's unquestioned. I think there's kind of a middle category which I think business associations falls into, and that is, it's not that there's anything that you're learning there that's fundamental to the legal reasoning mind, but it is something that you need to know to practice in the world. A little bit like con law. I mean, you don't actually have to know con law to go out and practice in, your normal small office, but you need it to understand the bigger context of many of the issues you're dealing with, and frankly, as a lawyer, you should just know con law. I'd put business administration or business associations in that kind of second category.
So can I ask you a question, Alan?
Yes, sir.
So why do we have 3 years of law school and we just have 1 year, get these core subjects out of the way, take the bar exam, and then apprentice people for several years? I mean, why torture people for 3 years if this is all they have to know?
I'm not the best person in the room to answer that question. Go ahead.
Yeah. So the suggestion is that we vote. So
Can I just add one thing to what Alan and Judge Reiser said, and that is the whole face and validity. I mean, removing some of these topics is going to raise some issues. Removing this one is likely to get a lot of pushback from the profession, even more than the specialized interest.
All right, so if you believe that business associations should be in, raise your hand. Okay, so then it's out. All right, so
now I've created purple and red and green. Green is in, red is specialization. Purple is professional responsibility, employment, business association, although Jackie, you made a great point for actually using our data, which would suggest employment would be in. But these in purple is, let's look at another way of testing outside of the bar exam. A testing or a course eligibility to sit for the exam requirement, some kind of other requirement. So I think if folks are comfortable with that, we could move to competencies.
yeah, so I see that employment is purple, potential other way of testing. Is everybody in agreement with that? I still had a question mark by it in my notes. Maybe I just missed the consensus a little while ago. We're okay with that plan?
Hang on, sorry.
Thank you, Emily. So is it the consensus of the group that we're testing on 7 legal topics and not 10 like I proposed earlier? I don't see what why are we doing 7 and not the 10 that I proposed earlier? And I think if we include the 2 or 3 other topics, and maybe that can take care of some disagreement between some of the.
Which are the other ones? Which are the other? Are these the other?
It bears noting, although the MBE didn't come up as much a topic, just once, I think, in the topics on it, that independently, the group appears to have agreed on the same 7 that are on the multi-state bar exam.
And what were your other 3?
I don't know. What were your other?
Oh,
Wasn't these, because I just wrote these down.
yeah, that's what I thought too. I thought it was the 3 purples, but.
Maybe so.
I am also worried about Jackie's point, which is the policy decision that this working group is making to say, yes, we see that employment law is up there in the rankings, but we don't want to put it on the bar exam. And are we saying that because it traditionally hasn't been and we don't see it as core? Or are we, I mean, like I had said before, I don't know that it is just to California and not sort of core legal for the nation, and maybe I shouldn't be worried about that. But I guess I'm raising that point. I don't know that I'm ready to say, yes, it should be on, but I'm not like slam dunk, no. Sorry.
But I think the response to that, Emily, is that we are really sitting down and thinking outside the box. We're saying, yes, it's important. We're going to integrate it into a law school or post-law school requirement, but we are streamlining the bar exam to those subjects, and we're going to be testing on issue spotting and analysis. We're not, I don't think any special interest is going to be mad if we put a subject as a requirement another way, whether online
or make it red, right? I mean, we could have a specialization in employment. It's a finite area.
I would make the same argument for employment law as I would make for corporations. I really do believe that the issue in California is employment is California. All the wage labor stuff. I mean, California's got a set of employment laws that just go beyond any place else. It is California specific. Also, let's take corporations. What does one teach? And by and large, what is on the bar exam? Okay, it's basically corporate formation, the different type of corporations and things like that. Corporations are state creatures. Okay, so I really do believe that both corporations and employment could be taught, could be a separate exam, like the New York exam, that would deal with California corporations and California employment law. The other stuff, typically we teach in corporations is stuff like securities law and stuff like that, but those are by and large federal issues. So that's on the basis of which I can think that we could make an argument both for employment law and business associations that they're California specific, we can test them separately, and our goal is to narrow down and get to legal analysis, and we're getting the main concepts. I think Robert spoke about it so eloquently.
Yeah, we can come back.
And so the original ranking was based on the original composite computation, drafting and writing, issue spotting and fact gathering, research and investigation, counsel and advice, litigation, negotiation and closing, maintaining client relationships, communicating case matter management, establishing the client relationship, supervision and collaboration and practice management. So that is, drafting and writing, and then, so research and investigation is second on the new list. It was third originally. Issue spotting was fourth on the new list. It was second on the original list. Counsel and advice was fourth on the original list and is sixth here. And litigation, it was fifth and now is third. The difference is communicating shows up in the top set here, the top 5, where originally it was a little farther down. Negotiate, so do you want to follow the same strategy?
Sure. Yes.
I don't know on the strategy, I just, is the idea that this group would be making recommendations to the court that these competencies should be tested somehow, but we don't know how or whether it's feasible at this stage, right? Because we're not, right now, you have no experience, I gather, in testing, communicating, for example, or establishing, well, I mean, even drafting and writing it. Well, because, you know, an essay examination is hardly a real good example of whether a person can write very well. Right. So that's my concern is that I think everybody would agree. You wouldn't find a lawyer, I think, of reason and judgment that wouldn't say all those things are important to the practice of law. I think the overriding question for you is, do we think we can actually test those? And that's a question I've been asking since the first meeting. And I'm not saying you can't. I just don't know of any current methodology that's been adapted that's reliable and valid.
So certainly some of these, you know, have are world of credentialing testing that are for not being testable. Something like communicating is definitely difficult to do. So I guess my thought around the role of these in the examination program is that they would supply context to the problems that are presented based on legal topics. So the problem that's presented would be twofold. It would present some kind of an issue to be resolved related to the legal topic, and in the phase of practice related to one of these areas, particularly it seems like negotiation and closing and litigation, counsel and advice are 3 areas that come to mind as being relevant. But that's an outsider's view. I don't know.
Yeah, well, I mean, I hear you, Doctor. I put all these topics in these contexts, but let's take negotiation and closing, you know, well, not closing so much, but negotiations. They're all manner of negotiation techniques and terms, some effective for different people. And the problem is in a bar examination, you really have to have a correct
answer.
And for so many of these, it's just hard to find a correct answer. Research investigation, if you could somehow develop an online test, see whether somebody can actually research a problem. But you got every one of them, you need to have a correct answer. And many of those topics, it seems to me, it's difficult to say that there's a general consensus on a correct answer.
Why can't you have questions where some answers are more correct than others?
Yeah, isn't that the performance test?
They're not right versus wrong. Another question I have on communication, do we have the list of what went into that? I forgot what those lists are called. And I'm thinking about how I read some years ago that the MCAT incorporated cultural competency, and how you incorporate cultural competency into a standardized exam. That tells me that these kinds of difficult things can be done if they figured out how to do that.
At extraordinary expense when you're talking about, the patient interaction and that sort of thing, and they do it. But if medicine is a whole different ballgame in terms of their resources for testing and how many people they're testing and the like. And why can't you have one more than the other? Because then you have big arguments about which is the better answer. I'm just that's what standardized testing, where you have a multiple choice, where you have one answer is correct, the others are distractors. One may be a very attractive distractor, but the correct one is necessary, because it's the analysis on those that leads you to equate the exam. If you don't equate the exam, then you have an unreliable exam. And if you have an unreliable exam, you don't have a valid exam. You can have a valid exam, but you can have a reliable exam that's not valid, but you can't have a valid exam that's not reliable. Correct, doctor?
That took the words out of my mouth. So under communicating, there are 8 tasks. Some of them are fuzzier, but some of them are pretty straightforward and potentially testable. So communicating with opposing counsel or parties, we don't know what the communicating means there. Communicating other is catch-all. And then communicating with other interested persons, and communicating with witnesses, consultants, and experts. So the first 3 probably are nebulous, but communicating with witnesses, consultants, and experts, I'm sure there's some rules around that. And so testing the rules around that communication might make sense. Managing communication with other interested persons and managing communications with witnesses, consultants, or experts. Maybe the second of those 2 has some rules and testability about it. But then the last 2, determining disclosure or notice obligations and determining confidentiality obligations, both seem to me to be testable.
So, can I just on the issue of testability, which I absolutely appreciate, because I don't want to go down a road and then we're like, yeah, that's great, and then there's no way we can possibly make that work. But I do think that we need to somewhat think outside the box of, imagine an online test that is a responsive test, right? Where you are able to have a client in front of you that is asking you a question and you type in your answer. And then you have opposing counsel in front of you that's saying, hey, I want to do this deal, and you're putting in an answer. Or you're clicking one of 4 possible responses and you choose the best response to that witness or to that counsel or whatever. And I think that there could be a team of folks that would say, yes, this is the better answer. So I recognize that that cannot be for everything, but I do think we have to get out of the framework of I'm just going to, respond to a written page. So for me, I would take down the bottom 4, because just looking at, I have the task lists here that we just read for communications, and looking at the bottom 4, I don't see that as something, I think it's great, but if we're going to eliminate stuff, I think those are things, looking at the task list, that can be done later, either through MCLE or something, not on the exam. And then I would use those other competencies, and maybe you don't test them every time, but students are going to be responsible for them, and that's where I would go.
So, am I echoing? So just reacting to something that was said earlier, sort of in combination with what Emily was saying. So I looked at the competencies. This is in response to the idea that maybe there are some rules surrounding the way you communicate with witnesses, et cetera. I looked at the competencies as the alternative to the substantive knowledge that you needed to memorize. And so that sort of suggestion that we could test it because there were specific rules that you needed to know seems to fly in the face of that to me. So I think we were thinking about, for these competencies, right, understanding sort of the way that, you know, the skill, developing the skill set. This is a skill and not a knowledge, a subject matter content issue. So I want to make sure we don't lose the focus of figuring out how to test the skill, not the underlying rules that go to that particular topic.
You know, Grab, you get to the heart of what continues to bother me and concern me. But it seems to me if we're going to be testing any of these, we're going to be testing subjectively. You can't test these skills doing multiple choice. And the only kind of examination that's not subjective is multiple choice. That's a too bold statement. I don't completely believe it, but to the extent there is the case. But we got to do better than that. And for example, I think one can test communication. What is the way in which most lawyers communicate most of the time? It's by emails. And they're communicating with courts, they're communicating with people in their own firms, with opposing counsel, and with their clients with emails. And I draft hypothetical performance tests when I teach in the spring. And I say, this is what's happened, okay? Draft an email. It's urgent. Because that's what we have to do these days as attorneys, okay? We have to draft something that does what it needs to do, either to inform the other side or inform our client or inform the court or something like that. And I think that is a skill that can be tested. You draft it in the context of a performance test. And I think there's some, again, is it subjective? Yes. I think if we eased up on the pass score and all that kind of stuff, a little bit more reasonable in terms of expectations, then that would work. But I think that's really the challenge. I think a new testing method.
I want to say I'm not opposed to testing these issues. I'm not opposed to that. I mean, if you could figure out a way to do it, I think that's great because everybody recognizes that these are important things to know in the practice of law, and you learn them by practicing law primarily. But the difference is that the key issue is cost and reliability. Those are the two key issues, in my view. So I'm not opposed to it. I'm just telling you this is if you make a recommendation as to a lot of this stuff, you better know what you're recommending because then once that becomes a policy, then you got to test and examine. And then where are you if you don't have a good base of knowledge? And I don't think the group here has a base of knowledge of how to test them because as Dr. Anderson just told us, you know, it's not uncommon that in professional testing, we don't have those kind of testing, even though they're recognized. And so I mean, lawyers have learned to practice law since the 19th century, maybe before, by actually practicing law, right? And what's changed is in the late 19th century, we've got law schools where they taught a lot of doctrine and legal reasoning. So no argument, I'd vote for it. I just think you're heading down a path that's going to be rather difficult not rather difficult, very, very difficult to achieve given the resource you're likely to have.
But,
I want to echo what the dean said. I think that we can stay on our path. And Lisa, you can tell me. I think that these communication things, they're made for our performance test. Can you think of a performance exam that's kind of addressed these kind of? Lisa's knows every bar exam question in her head for the last 100 years. So have we touched on these kinds of issues in our performance exam in the past? Communication, just like the dean said, write an email, communicate with, it seems perfect for that kind of.
Yeah, most of our tasks, performance tasks, more recently in the last probably 5 or 6 or 7 years have been either a persuasive memorandum or an objective memorandum. So, you know, in my directions to the PT drafting team, I've asked them to come up with maybe some other creative ways to, you know, other tasks that maybe an entry-level attorney would, you know, be doing. So, you know, we've had some other things, but mostly they fall into the category of drafting a persuasive memo or an objective memo. So, you know, there aren't any drafting emails or anything like that, at least not, you know, in the bank that I have, but not to say it can't be done in the future.
I mean, does it seem like something, now that you've seen the data, does it seem like something that your team could
I mean,
put together, that we could have a criteria for grading that's fair and?
yeah, I mean, there's a lot of creativity, I think, that the performance test drafting team can, you know, yeah, I mean, I think it's possible.
Let me just say, I spent 10 years on the MPT drafting committee trying to do this stuff, and I can just tell you, you finally just throw up your hands because it's all about the grading and it's really tough. And we got close on a couple things, but you end up with the kind of questions that were just discussed: persuasive memoranda, objective memoranda. It's largely, I mean, it has the advantage of you give the applicant all the law they need to know in order to answer the question. So it's you find out where they can take the facts given and a library of materials and then come to a memo or whatever the task is. But you don't find the MPT, even though we thought a lot about it, testing these kind of skills. And MPT in your performance test has a lot of facial validity. I mean, if you ask students, applicants, and lawyers, oh, this is what we do, this is, but in truth, it's not. It's really, in many respects, a glorified essay question. Now, you do get more, I think, because you get the whole business of taking the facts and the library and putting it together. But that's as about as far as it goes.
Can I just ask, in terms of what we're trying to accomplish right now, are we trying to winnow down the competencies akin to what we did with the legal topics? And then if we applied the same principle, so we took those at a 10 or up, so we'd be from counsel and advice up to drafting and writing. I'm wondering if it would be helpful to look at the subtopics, because, and then within the subtopics, you can see the relative frequency, right? So, because, it's interesting to look at drafting and writing, what is that? Drafting correspondence, using exemplars, drafting pleadings, drafting, I can't read my own writing, drafting discovery, drafting legal memoranda, drafting contracts, redlining documents. So I think it'd be helpful for us to say, all right, we're going to look at this set, and then we're going to look into the weeds on them. And then this is what our recommendation is going to be in terms of what we test.
And sorry to follow up on Leah's comment, when you look at the breakdown for communicating, which is showing up around the middle of our list here, you look at the breakdown of tasks, by far the highest rated task is communicating with opposing counsel or parties. So just pointing that out. Oh, the handouts that we got for our last conference call?
Right, the last
Yeah.
meeting, right. So, my understanding of what we're trying to do at the moment is we're getting caught up in test design questions and issues, and my preference is that we not do that just yet. I mean, we are going to have to wrestle that down at some point, or that is the state bar is. Whether that's part of the work of the working group or not is a different matter. But the thought is that if we identify which of these it is are most readily classifiable as core skills. We got the core knowledge nailed a little while ago. So which of these would be classified as core skills? And then we'll deal with the accessibility issues at another time. So one suggestion is that we follow the same strategy of making decisions that we used in with the legal topics, focusing at the bottom first and dropping off, the bottom 4, which would be case and matter management, establishing the client relationship, practice management, and supervision and collaboration. Drop them. Okay, then at the top, drafting and writing. appears to be core, based on the data. Negotiation and closing.
Can I just read the tasks on that real quick so for everybody? Participating in negotiations, coordinating closing of a transaction, explaining the terms, conditions, and status of negotiations, negotiation and closing other, representing the client in mediation of transactional disputes, coordinating the roles and authority of participants in negotiations. Just don't know that that's.
Just to go back to what Leah was saying before, and doing a green for those that we think might be important to include in the bar exam versus those that we think might be important to licensing in general. And I think that will also help us get around Greg's concern about what is testable and what isn't, because I'm thinking about this in terms of what should be on the bar exam, and then what might be so critical to licensing to the State Bar of California for public protection purposes that they would want to know that all licensed attorney either were exposed to it in law school or were exposed to it within the first year of, or established their competency within the first year of licensure, whatever the case may be. So I would welcome that same kind of division between, like with negotiation and closing, is that something where we would want a CLE within a year of practice on negotiation and closing because we think it's so critical based on the data? Or are we willing to just say, nope, it doesn't matter?
So as a professional negotiator, this is an advanced skill set, right? And if you look at these numbers, the 1, 2, and 3 year attorneys, obviously it goes up as with the experience. And so the first year attorneys, do they have to know negotiation and closing? No. I mean, it's one of those things you develop, right? It's not an out of the box thing. So on this one particular issue, I think it's probably not something that you want to test. You know, after the 3rd year, yeah, maybe, right?
I've taken the liberty of just putting the everything 10 and above in green, just to move our conversation forward. Is there anything in there that you think should be taken off? Because I think the harder work is getting into those subtopics and.
That's good. Yes.
Yeah, I think that's good.
Okay.
I do want to speak to the maintain client relationship as being added, but if we're there, I don't know if we're there. But.
Sure, that's where we would go. You've taken the top 6, then that's the next one to talk about.
So that says updating the client throughout the matter, responding to client inquiries, maintaining relationship other, resolving disputes with clients, documenting termination of the representation. And again, Greg's testability point totally in effect there, but
Well, some of that is tested.
some of it is, but maintaining relationship, like that's, you know, I don't know. But I will say that to me and for the public protection aspect, I mean, this is a huge reason why attorneys are involved in all of the moral character issues that they are. So I just sort of feel like that should be in.
That would be a professional responsibility issue, right? Update the clients throughout the matter, respond to client inquiries, resolve, I don't know about resolve disputes with clients.
Yeah, it could also be folded into communicating if we put those tasks under that. So, I mean, everything could be kind of communicating, right? But I just think specifically having those maintain client relationship is important.
That's a wonderful place to have a crossover question between professional responsibility and communicating, right?
A lot of those issues are covered in the rules.
So according to my notes then, we have included drafting and writing research, and investigation, litigation, issue spotting, communicating, counsel and advice, and maintaining the client relationship, and we are not including the bottom 5.
Well, I'll say it. How will we test litigation?
When you look at litigation,
Yeah.
the 2 biggest things by far are appearing at hearings, appearing at trial. Next biggest, preparing for trial.
They do a discovery plan now with the PT. At least they have in the past. They haven't tested it in a while. They, meaning y'all, sorry, the state bar. So they used to do discovery plans and sort of deposition plans. I don't think those are great. I think those are really hard for people to kind of prepare for, but.
I think the way you would be able to test it is really with the model, Emily, that you were talking about earlier. It would be an online interactive kind of exam that says you're in court. This is what happens. What do you do? That's the way you would test that kind of skill. But if we start with these, then I think the next step is to look at the what Neil is looking at, because it has both the tasks and then the frequency. I don't know if we have the ability to put that up. It's also 10 minutes before 3, so I'm not sure what's realistic.
There's a bazillion of them. I would suggest we put that for the next one.
Okay.
Just going to make a comment just about the adaptive testing. You know, medicine, I hope I haven't said this already, but medicine will have a situation where they'll, on their test, they'll present the patient presents with these symptoms. What do you do? And then you, what test do you order and that sort of thing. And then depending on how that goes, and it's time, there's an artificial time thing. This much time has passed, and here's this. You can see how that can be very, very complex, and you then have some pretty good rubrics on what's done. I mean, I represent a healthcare system, and eventually doctors were forced to basically conform their practice to what the data was suggesting should be appropriate. If we had those kinds of standards in law, great. And if you have the resources to develop that kind of computer adaptive testing, great.
I would call that a simulation test. And there is some adaptive aspect to it, but the value there is that you present a lifelike problem that an attorney at the entry level is likely to come across or should reasonably be expected to come across. And then the decisions that individual makes drive the selection of the next problems that come into play. And there would be a correct pathway through the problem. There would be pathways that may be circuitous but would get you to a good outcome still. And there would be outcomes that, or pathways that could only lead you to outcomes that would not be right. Right.
Well, yeah, we don't, in 5 minutes.
So the objectives then, over the next term, we are coming toward the end of the project, and so some things that are immediately on my desk are to finish drafting a final report for this study. I'm well into it and expect to be able to get that out for your review prior to our meeting in December. And then we have some detailed work to do in the next meeting about making decisions around whether we want to recommend percentages for any of these areas, or what kind of overall plan for the test we might foresee. But it would have to be at a very high level, I think, in order to accomplish that discussion in the next meeting. So our work is still cut out for us, but just think about how far we've come. And it was really interesting a few minutes ago to hear you talking about the assessment of skills and the need for all of that. That took me back to the very first meeting that we had that I attended by conference call. And that was the first discussion that you had. So full circle. So I think we've accomplished a great deal today. I'll step back unless there are questions for me.
I have a question. So are we going to, in our last meeting, going to address two thorny questions? One is the issue of experienced attorney reciprocity in terms of admission, because we've been begging that question, which is, in my mind, huge. And then the other question relates to cut score. Is that outside our scope? We're not going to talk about that. We're just going to have to write letters to the chief.
So the cut score would be determined based on, after a first version of the test is put together, then there would have to be a cut score study for that. You couldn't just take the cut score that you've established for your current examination and drop it onto the other. There's no reason to think that the two tests are equivalent in difficulty. They certainly cover different ranges of content, and so my recommendation would be a standard setting study at the appropriate time. The other conversations about reciprocity for experienced physicians, I know all those words, I just don't think I've ever heard them in that order before. So I don't have any background on what that issue is.
No, and that's kind of a policy issue that's not under the scope of this working group. I think there will need to be some time set aside at the next meeting to identify all the outstanding issues and questions and things to do, essentially the to-do list, because we aren't going to get into specific test design either. That would be, I think, for a subsequent phase. So there's a lot we're not going to do, but we will hopefully identify the legal topics, the competencies, and hopefully get into some of that weighting. So when is the next meeting? Okay.
December 20th.
So I wonder how you're going to have a draft of the report when we haven't completed this exercise, because this seems like the main deliverable.
Right. Well, so the report's going to summarize the everything up to that, and then that'll be the ultimate conclusion section of the report.
I know you've got your deadlines and maybe relate to what the Supreme Court's expecting, but to some extent, you might think about seeing what the they're going to release in January. Maybe you ought to talk about it, because you're well, it might be informative. I mean, you might find that there's a lot of agreement between the National Survey and the California. It wouldn't surprise me, because it seems to me that I have a hypothesis that the practice law in California is not that much different than the rest of the country. But
except unemployment law.
Except unemployment law. Well, anyway, I don't know if there's room to ask the court for a little more time. That's entirely up to you, but it might be informative to you.
It's actually not the Supreme Court that set the schedule, it's the Board of Trustees, so.
But we did do a crosswalk, recall, after the practice analysis panel meeting with several other outlines. One of them was the outline that the NCBE was surveying, and we found great commonality across it. So you're correct about practice of law being consistent with practice of law outside California.
Okay, well, thank you everybody for attending and working through a lot of issues today. Thanks, Jim and Ron, for the very helpful charts and reduction of all of that data to some really informative presentation. So the next meeting is December 20th in San Francisco, and at this point, we still have a mandate to have our report prepared and submitted by December 31st. In the meantime, we'll see if that's adjustable, but for now, let's plan on one more meeting, the 20th, and if we can do it for a 12/31 submission, we will, and if not, we'll hopefully have some leeway.
Who's going to be able to attend on December 20th? Just to check. Unable to attend. Unable to attend. Yeah, I know.
I got a plan. Oh, God. So most everybody's available? Yeah. I mean,